Good morning, good morning, good morning, amazing. Leonard, it's Tuesday. We are going to court from Monday afternoon. But before we do that, there is a story that I saw last night as I was getting ready for bed and then early this morning that we have to talk about in the Kouri Richins case because I can't not. So Leonards, you'll have to indulge me as we do like a brief side quest, and then we'll decide if this side quest needs to become more of a quest. If any of you are also like, Emily, are your lights different? One of them's not working. It's fine. We're ignoring it. It's all going to be fine. It's all going to be fine. It all works out. It's all going to be fine. We're just doing the things. It's been a busy morning already, Leonards. I hope you're doing well. Let me know where you're coming in from, what you're drinking. Unlike Friday, was it Friday? Was it Thursday? Was it whatever? Unlike the last hearing we saw in Karen Reed that I had seen because I was recording it and then wanted to sound balance the judge, I have not seen this one. I don't know. I have not seen this one. I do not know what is going on. We are going to watch it together. Thank you for no spoilers. We'll just see what happens. I didn't look for any of the updates about it. I looked at what was going on yesterday to see if it was going to stream. And then there was like weirdness. And now we've got video from yesterday. So I didn't look for any headlines. We're just going to cover whatever happened in court. For those of you that are not caught up on the Karen Reed saga, we'll do a brief road so far on this hearing. We're not going to do the most in-depth road so far because at this point, what are we even doing? And then, well, before that, we've got a quick Kouri Richins story that we have to. I've got some coffee. Have I had chance for coffee yet today? No, I haven't. But I've got some coffee. I'm gonna do coffee with you, and we're gonna watch that hearing together. Do I know how long it is? It says it's like 45 minutes long, so we'll see. I don't know. We're gonna find out together. Emily, what have you been doing? All of the family things, life things, all of the things, just all of the things, and with all of that, we've got quite a lot to do today. And with quite a lot to do today, we're going to get into it. Tara, it's good to see you. Tara said I had asked if you would cover a story out of the housewives world. I retract my request. This is why we talked about it when we were recording the podcast. Did some quick research on my own. Look, Tara, I appreciate it. And for those of you that are members, you know that we record the podcast most of the time with the members in the background. And we always have a little chit chat before and after. We have some podcrastination and we chat about things. But we talked about it and how I kind of evaluate what we're covering, what we're not covering, when we're covering something, and how. And there are some stories, especially when we are dealing with, children of celebrities and things like that I will take a look and ponder first if we're going to cover it, because especially when it comes to like children of reality star TV shows, they didn't necessarily put themselves into the spotlight. That wasn't their choice. So I always tread kind of cautiously as we talked about, and then we'll see. But those are the conversations that we have, A, on members only, and B, when we are doing the podcast recording, as we kind of talk about the other things that are going on, some things I might cover, some things that are a side quest, all of the things. So with all of that, we should get right into our intro, our first story, our coffee, all of our things. We should get it. We should do all of the things because Leonards, we have to go to court today. We have to go to court. And for those of you that missed the podcast recording, do not worry. As I said, the podcast recordings do not stay up, but the members only do. And we're going to do a members only stream tomorrow. And I am very, very excited about that. So we're going to do a members only stream tomorrow. So that will be tomorrow's stream. So if you're looking for me tomorrow morning, don't worry, we're on members only. So that's what we are doing tomorrow. And then I'm traveling just a little bit. So we have lots to cover today. If anything gets wild, I'll let you know in the app. So that's how we roll if anything gets crazy. So if things get wild, I'll see you in the app. So tomorrow's members only stream will be around the same time as our normal stream, unless something changes. This morning, Travis needed some stuff handled. If that shifts, I'll let you know in the app. That's why we have an app. So we can just keep you in the loop with everything, because it's time. It's this kind of time. Chloe UK said, Emily, what time is members only for us in the UK? Or this time. Whatever time this time is, around this time. We're going to be doing it around this time. So this time, and we'll if I change that, I'll let you know in the app. So let's roll the intro. I'm ready. This coffee looks delicious. I'm ready to coffee. I'm ready to coffee. And it's time to roll. Leonard, are you ready? Let's go. I moved the audio so it should go where it's supposed to go. And alas,
I break down the law, the strategy,
and the
Hopefully
evidence
you can hear it better. In real time, so you know what's happening. No law degree required. So join the law nerds in the chat. They're here for the facts, not and let's get to court.
we have to get to court. I saw one of you in the chat being like, EDB, you're missing Dave, the story of my summer. But I'm trying not to be salty about it. I know I am missing so many Dave shows this summer. I can't tell you, but you know what I'm not going to miss this summer? I'm not going to miss a bunch of Cavaliers performances. And so I have put the priority on making sure I can go see my kiddo, but it doesn't mean I'm not sad about it, because I haven't been to a Dave show yet this summer and I'm starting to twitch. Like it's solidly mid-June. It is mid-June and I have not seen Dave yet, and I am starting to twitch about it. I know it. Adulting is hard, everybody. Adulting is hard. Adulting is hard. File this under adulting is hard, because it absolutely is. This is one of those things where I'm just like, adulting is hard. I love my kiddo. I cannot wait to go see him, but also sometimes adulting is hard. So I have just not had enough time to get to a show. I got to go see Evanescence because they were here in Nashville, and that was lovely. Okay. I love that a number of you have been like, Emily, we're coming with the KR squared today. We are. We got to talk Kouri Richins first. Okay, look. Kouri Richins. For those of you that are newer or did not watch the Kouri Richins trial, don't worry. I will give you all of the background that you need for this story. Kouri Richins went to trial February, March, though her lawyers keep saying that the jury returned a verdict on St. Patrick's Day. They are incorrect. It was the day before. And we are in the waiting game of what the motion for new trial is going to be. Normally we see a motion for new trial or a motion to set aside the verdict fairly shortly after conviction, though we saw it a little bit later in the Banfield case. They ended up arguing that the day before he was sentenced. But we see those motions that are really generally pretty aligned with what we saw at the end of the prosecution's case. Now, in the Kouri Richins case, I don't know what else they're going to say. They didn't put on a defense. I don't know what else you're going to argue. Like, what else are we going to argue? You're going to be arguing the same thing you argued at the end of the trial, because a motion for a new trial is essentially that there is something that is glaring. This shouldn't even go to the Court of Appeal. The trial level court should just grant this motion for new trial. And they are going to be able to argue, well, they are not going to argue that until like September. But the defense had asked for more time. We are waiting for that to be filed. In the civil cases, there was a big ruling from Judge M that is going to impact the civil cases. However, Kouri Richins still doesn't have a lawyer in most of those cases. So, you know, if Kouri Richins still doesn't have a lawyer in those cases, what are we going to do? Because Kouri doesn't have a lawyer in the civil cases. And that is a absolutely wild thing. Like, what do you mean you don't have a lawyer in those cases? So Kouri doesn't have a lawyer yet in her civil cases. Her lawyers have asked to yeet themselves off of her criminal fraud case. So we're waiting for a hearing on that. And they're like, hey, we got to go. We've not been appointed for this case. And like, I get it. But I wonder if Kouri was just like, but you're my lawyers. And they're like, no, girl, we're not getting paid. We're not getting paid. We're not here just for fun. We're not getting paid. So her criminal attorneys are still her criminal attorneys on the murder case as we get to the end of her motion for new trial. And then it will get handed off to appellate counsel. And then they will be off and away. But we still have to see what counsel comes in for appellate counsel and then what counsel comes in on the fraud case. Because remember, she still has a pending financial crimes trial. And then, like all the things aside, the lawyers that are going to be allowed to yeet off of the financial crimes case because, well, they don't have a contract to do that case. And of course, they're going to be able to remove themselves from that case. And we've got all the other things. But when we look back at trial, there was one witness who has gotten himself into a more than a wee bit of trouble since trial. And not the good kind of trouble, not the like come and hang out and chat with EDB so we can all stand type of trouble. No. Actual trouble. And that's Robert Crozier or Crozier. Do you remember Robert Crozier? Mr. Crozier testified that he didn't remember shit. Remember how the defense was just like, oh, boo-boo. The defense wanted to be besties with Mr. Crozier. The defense wanted to come after Carmen Lauber like she had, like I can't even. The defense wanted to go after Carmen Lauber without any regard for anything. And then when it came to Robert Crozier, they were like, oh, hey, buddy. What's up? And we started hearing about Robert Crozier in the pretrial motions. And do not fear if you did not do all the pretrial motions with us. Don't worry. In the pretrial motions, the defense filed this motion and was like, Your Honor, a key witness has retracted their statement and the prosecution has no case and it all must be dismissed immediately. And I was like, girl, it was some of the most dramatic motion writing, well, that we have seen in criminal court. It was so dramatic. And it was, he has retracted his statement. Oh no, the entire case must be thrown out, Your Honor. Well, what it turned out is that Crozier was like, I was like high and or detoxing, and I don't really remember what I told law enforcement, but I definitely didn't tell them that I sold fentanyl because I definitely wasn't selling fentanyl because I definitely didn't sell fentanyl at that time. I was selling blues at that time. Mind you that at that time, the testimony was that everything on the street, including things that were made to look like blues or fentanyl, everything was fentanyl. Right. But he's like, I was definitely not doing that. I was not selling any of the fentanyl. And I was detoxing and I couldn't even remember what I was saying. And I didn't know anything. And then they just rolled the tape and he's sitting there talking to the cops and he's like, I mean, yeah, I was selling this for this much. And it all kind of aligned with the fact that it would have been fentanyl because it was the same type of pills and the same type of price and the same type of this. Right. And so they rolled the tape and we were just like, But his big kind of boo-hoo to everybody was that he was sober and he had been detoxing. And I have a lot of empathy for that because that can be a real thing. And that is a real thing. And that can be a very difficult thing. However, I did not find him very credible at all. And so him saying that he was doing all of that, I did not believe that's actually what he was doing. I believe that was a convenient excuse because once we saw the video, it was pretty clear that he was just like, hey, yes, Silency said, Mr., I didn't write my own statement. Yeah, Mr., the defense keep putting the wrong drug on there. I wasn't even selling that one. Oh, well, the defense just typed that up for me and it was fine. But Carmen Lauber being like, if you guys could just handwrite it down, I don't want to write it. If you could just write it down, like what I'm saying, that would be fine. And they lost their minds. But then Crozier, they're like, let us type that up for you. And he's like, this isn't correct. Yeah, that guy. Well, he got himself into a bit of a pickle. Now, I'm going to say, arrests are based on probable cause. Probable cause is not proof beyond a reasonable doubt. Just because someone has been arrested and charged with a crime does not mean that they are guilty of that crime. They retain the presumption of innocence. However, Mr. Crozier has gotten himself into a bit of a difficult situation. And if all of you are like, Emily, was he popped for selling drugs? I wish that were the case because it would be better. Yeah, it would be better. And for everyone in the chat who has seen this story this morning and has not spoiled it, y'all are the MVPs today. Alleged drug dealer and witness in the murder trial, arrested for attempting to meet 15-year-old for sex. Now, if you are concerned, this was a sting operation. I'm going to tell you that. Spoilers, this was a sting operation. No 15-year-olds were actually put in danger. This was an ICAC sting. I'm just going to put that out there right now. It was an ICAC sting operation. However, sir, the only way you get caught in sting operations is if you're doing things. So we're going to take a look. Right. For the purposes of the crime, it does not matter that the person on the other end of the devices is not 15. For our purposes, so that the law nerds can sleep at night, I think it matters to know that this was a sting operation. It doesn't change what he's going to get, what he's been charged for. That doesn't change. But I'm glad that there was not a 15-year-old on the other side of that. I know the law nerds were like, nope. I understand. We ready to continue? Are we ready to continue? This is from ABC4, Utah. Emily fights with technology. Hold on. We're close though. We're close in the world of Emily fights with technology. We're almost to where the news articles that are all formatted differently are readable. Look, we're so close, law nerds. Look at this. We got it. Oh, almost. Sorry. I'm going to have to put this on reader mode because at least that's consistent. There are so many pop-ups. Okay. Now that we have navigated every pop-up that exists in the world. Box Elder County. I don't know where Box Elder County is. I don't know. Is there a Maverick? I need to learn. Is there a Maverick? You let me know. A Midvale man who testified at a high-profile murder trial in Park City earlier this year has been arrested after attempting to meet with an undercover agent posing as a minor online. Robert Wilson Crozier, 47, has been charged with 2 counts of enticing a minor to first-degree felony sexual activity, 1 count of distributing material harmful to a minor. You can guess what that entails. It's not pictures of Fred and George. For those of you that are new, Fred and George are my cats. Right? OPP. 2 counts of enticing a minor to third-degree felony sexual activity and use or possession of drug paraphernalia. They go on to say, notably, Crozier was a key witness in the alleged drug dealer. I don't know if it was alleged after all of this. Crozier was a key witness and the alleged drug dealer who provided the pills that Kouri Richins used to murder her husband in 2022. He testified during her trial earlier this year, after which Richins was convicted and sentenced to prison. Life in prison without parole. They left that part out. I'm just going to add that in there. On June 6th, an investigator with the Box Elder County Attorney's Office who works on the Utah Internet Crimes Against Children. Do not mess with ICAC. They will find you. And I'm glad that they do. The ICAC task force was conducting an undercover operation online. The investigator was posing as a 15-year-old girl on social media. I saw a few of you in the chat ask, wouldn't this be entrapment? Somebody posing as a teen online is essentially bait. I hate to say it that way, but it's putting it out there to see who bites. It's not in putting them in a situation where there's only the option that they do the thing. They are putting it out there to see who contacts this minor on social media. So no, it is not entrapment. So it is seeing who will engage with the conversation. So there is choice, and they do not tell them what to say. They do not tell them what to do. Nobody is threatening their life or their families. So no, not entrapment. This is a sting operation, and these happen all the time. Sting operations are expressly allowed. Documents say that he messaged the undercover agent asking for her age. When he was told that she was 15 years old and asked about his own age, he allegedly responded, well, goodness, I am way too old to know better, with a kissy face emoji. During the conversation, Crozier told who he believed to be a minor that she, quote, might turn me into a creep. Sir, I got some sad news for you. If you're messaging a 15-year-old on social media and are excited to find out that they're 15, yeah, that ship's already sailed. Shit's already out of the horse. He asked sexually inappropriate questions about the teen. He reportedly sent an explicit image of himself, gross, and asked for images in return. Documents say that he also discussed the acts he wanted to perform on the 15-year-old. The undercover and Crozier began making plans to meet in person, and he allegedly offered to bring marijuana and methamphetamine for the teen to, quote, make the intercourse better. I'm sorry, sir. What did you say about the 15-year-old turning you into a creep when you're suggesting that you will just drug someone? Okay. They set the meetup, and law enforcement says that Crozier used public transportation from Salt Lake County to get to the meeting location. When he arrived, he was taken into custody and searched. Inside his backpack, law enforcement reportedly located drug paraphernalia in the form of a needle. What? No drugs? I'm shocked that he's not in possession of drugs. Also, I'm concerned about what might be in the needle. He was brought in for questioning, during which he allegedly admitted to knowing he was talking to a minor, to sending her an explicit image and requesting them in return. He claimed that he didn't really remember those events because he was high on methamphetamine a lot, but it was likely that he did them. Didn't you testify about how sober you were less than 3 months ago? When the defense was just like, hey, bestie, congratulations on your 7 seconds of sobriety. And the reason I mock is because I don't think he was sober at all. I think it was just bullshit. Where Carmen Lauber, who I do think is fighting for her sobriety, was treated like shit. And it still pisses me off. The little drummer boy pointed out correctly, bro couldn't remember his sobriety date, right? MT said, oh, he didn't remember again? There's a pattern for this. Yep. Serena, congratulations. Serena said 2 days ago was my 12-year sobriety date. Congratulations. There are so many of you that are sober in our community and that have worked for that sobriety and fought for that sobriety. And that is an incredibly difficult thing to do. But to weaponize it and leverage it the way that he did in court was gross to watch. It was just gross to watch. And it was infuriating. And I'm still pissed off about it, obviously. But the same fucking excuses. Same excuses. I'm high a lot. For all of you who didn't remember Crozier and you're listening in the background, there's a picture of him on the stand in the pink shirt. Remember, he tried to have like the crip walk when he came into court. Couldn't quite pull it off. That guy. He's that guy. He's that guy. So he said that he doesn't really remember the events, but it was likely that he did them. Sir, that doesn't, do you know what that doesn't tell me? That doesn't tell me it's not giving I don't remember. Oh, I probably propositioned a 15-year-old is not I don't remember. It's just distancing. Crozier was booked where he's being held without bail. Documents say he's currently on probation for another charge, and court filings show he has an extensive criminal history in Utah. Well, we're well aware. Mainly involving drug offenses. We're also well aware. So, Mr. Crozier, maybe, just maybe you'll get to reunite with your bestie, Miss Lewis. She seemed so fond of him. She was trying to make the jury think that he was just a good dude. That it was all the cops, He was sober. He didn't sell any fentanyl. He didn't even remember selling anything. So there's that. It's a lot. I'm not going to go through the more detailed probable cause affidavit. We know what we need to know. I imagine, from my experience with task forces like that, the amount of digital evidence they have makes it real tough. And once you're sending images of yourself that can easily be identified as you, it's pretty hard to argue that it's not you, especially when they track your phone. So I don't think this is going to go well for him. And I think that I was on drugs a lot, I don't really know, seems to be a consistent go-to for him. So we'll keep an eye on what's going on with Mr. Crozier. I imagine that this is a case that he will enter a plea deal and go to prison, and that'll be that. I imagine that that'll just be that. I will keep an eye on it so that I can tell you how much time he gets in prison. Because I think that's about all the further detail we need, isn't it? Do we need to know more? Do we want to know any more? I don't know if we want to know much more. Because those task forces are not grabbing you for an arrest if there's nothing that they have on you to use to prosecute you. So, yeah. All of you are like, yeah, no, we don't need much more. Right. I'll let you know if Miss Lewis ends up as his attorney. But the vibe a lot of you got at trial were like, I don't trust this dude at all. A number of you are asking, will this affect Kouri's trial at all? No. It's completely after the fact. He doesn't have immunity related to this. He had very, very, very limited immunity. My only question about Crozier post Kouri Richins trial is whether they would try to withdraw his immunity, because it did not seem that he was incredibly forthcoming in his testimony, and that might have violated his immunity deal. I don't know if they need to worry about it. I think that he's probably just going to go to prison for a substantial amount of time on this, and that's not causing me any great amount of distress, because what I unfortunately learned in doing a lot of computer-related and fraud-related cases, I never saw anyone who got caught the first time they were trying to get up to stuff. Ever. So, my thoughts on that are, this is probably not the first time he was messaging anybody. I can only hope that he had never met up with anybody. This is probably not the first time he's messaging anybody. So that concerns me. Which is why prison. Look. I have more thoughts. I'm going to leave it there. This does not fall into the category for me of crimes that I saw often analogous with addiction. You would see possession-related crimes, under the influence-related crimes, theft-related crimes for money, dealing and distribution because money and addiction. This is wholly to the side of that. This is a whole other thing. And he's like, well, I'm on a lot of meth. Oh, sir, meth doesn't mean you're going on like Instagram trying to message 15-year-olds. So I'm not really persuaded. So with that, I'll keep an eye on how this case goes, and I'll let you know. We know that Miss Lewis takes cases all over the state. Do you think he's calling her up? Just chat, tell me. Do you think that he's hitting up Miss Lewis? Because they were all up in his business when they wanted that declaration from him. You think he's just like, boop, 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 boop. Hey. So you said to call me if I ever needed anything, right? Right? I'm sure she's like, oh yeah, no, we don't, this is not in the wheelhouse of cases that we take. I wish you the best of luck. If she answers the phone. Because I absolutely bet he tried to hit up Miss Lewis. Maybe we'll FOIA his jail calls. Emily, too much? Nah, it's not too much. You know why? Emily, you don't normally go this hard on people. No, but you know why? The way that Lewis handled Crozier and Carmen was gross. It was gross. I hated everything about it. You can be a zealous advocate as an attorney, and sometimes you might be like, that's a little dramatic. But it was beyond that. And it was offensive to watch. So, no. I'm real curious. Because there were so many things that happened in the Richins case from the defense that I've just never seen before. I've never seen the defense give like these personal, impassioned pleas as their impact statements for their clients. I've never seen that. I don't even think that's okay. I've never seen it. And it was just wild to watch. So I'm just curious how this is all going to go. But also, I don't think we've seen a case where so quick in succession, we've had a witness end up right back in the crosshairs of justice. But also, to answer the questions about Robert Crozier, he has been arrested on multiple felonies. He's on probation on another case. He had immunity limited in the Richins case, predicated on his truthful testimony. There were a lot of questions about whether that immunity would get yoinked and he would suffer some consequences for that. And I think the consequences he's going to suffer are from this new arrest, where digital evidence is real hard to quibble with when you are sending photos. So it is going to be a difficult case for him to fight. I think it will probably end up in a plea deal with prison time. And the question for me will be how much prison time. That's my curiosity there. And I will let you know how that case progresses. But at the end of the case, there were a lot of questions about this witness. And I think this answers some of them. And it was just unnecessary the way that the defense fawned over him and then attacked Carmen Lauber. Oh, and then typed up his own little declaration statement for him, but also then got it wrong. The whole thing was just gross to watch, and went above and beyond the bounds of zealous advocacy for me. And that might not be true for everybody, because look, if you're the one sitting where Kouri Richins is sitting, you want a zealous advocate. But as I say with every attorney, you have to earn it. And they didn't earn the snark with Carmen. And I don't think they earned the gushing over Crozier, because at the end of the day, well, here we are. So I'm curious. Law nerds, we need to go to court. I know I promised you court. When I saw this story, I was like, I don't know if we're going to have time to talk about this the rest of the week. I knew there would be questions about, will this impact Kouri's case? No, the impact will be Crozier going to prison. It's his own, this is the find out. There's not much you can do with this. So we'll see. But with that, we're going to go to court. We're going to do a quick road so far on Karen Read. And also, we do have a sponsor today. So I am going to share our sponsor with you. It is the rebrand from Nord Protect. This is something that, as a product, I was very excited about when they came out with it, because as we are talking about everything you do online being known, sometimes the next step is like, what do I do if something happens? And this answers that question, because it's one thing to try to get your personal data off the internet, which I also do through Nord. But if something happens, what do you do next? And that's where today's sponsor comes in. So a huge thank you to Nord Protect, now Coveron, for sponsoring today's video. And then we will fly back to Massachusetts. Though I kind of feel like maybe we should have just been on a layover in Boston to hang out with the Tartan Army. And as much as I love the Tartan Army, I have loved like the Bostonians being like, farewell, my sweet fans. And then sending like messages to Miami of like, make sure they have plenty of beer and sunscreen. Like there is so much care and cheekiness and love. They're like, please be well, dear Scots. Enjoy Miami. Stay hydrated. Wear your sunscreen. Drink your beer. And, I'm sure it feels a little hollow from Boston, but from my obsession with the Tartan Army Boston mutual love fest that I loved watching, it also brought me to the Norwegian soccer team. These are words football team that I didn't think I would be sharing with you ever. But I'm also now obsessed. I'm obsessed with the like Viking row chant. I'm obsessed with Erling, and all of the videos of him like chasing people down on the soccer field. It's fucking terrifying. And it's amazing. And it's look, I didn't think I was excited about World Cup. I'm excited about World Cup. I'm excited about all of the World Cup things. I'm excited about all of the things. I'm excited about the Viking Row. I am excited about No Scotland, No Party. I am excited about all of it. I love the fandoms. I love how excited the fans are. I love every single moment of the social media, everything about it. I love people figuring out the difference between, you know, barbecue and then a dry rub and then a wing. I love the love for ranch dressing. God, I love all of it now. I'm so excited. I'm so excited. I'm excited by the enthusiasm. Do I watch an entire soccer game? I mean, they're really long, but I'm loving the fandoms. Like, I'm loving the fandoms. I love it so much. I love it so much. So if you are on the Instagram, which is where I am the most active on the socials when I'm not here, and you see comments or posts that I'm just hearting, if they end up in your algorithm too, you're welcome. I am waiting for the fleet of books that come after this. Ice hockey's going to have to move aside as a genre for a moment, because the genre of World Cup books, the books from this are going to be amazing. The books are going to be incredible. I love it. I'm here for it. A huge thank you to our sponsor. And then we're flying to Massachusetts. I love the enthusiasm. I'm ready for it. All right. Law Nerds. Thank you to our sponsor. Law Nerd, a quick break to thank our sponsor, Coveron. Coveron is a comprehensive identity theft and cyber protection service developed by the creators of NordVPN, and it combines the active monitoring that you've heard me talk about with insurance-backed recovery coverage that goes beyond identity theft to cover the detection and aftermath of online fraud, cyber extortion, and cyber attacks. We talked about this recently with that Charter Communications breach, about not only the breach of information being a problem, but then all the follow-up emails trying to say you've been a part of this breach and whether those emails are authentic or not. Coveron monitors the dark web exposure, credit activity, security threats across the personal identifiers that you register with the service. When suspicious activity is detected, Coveron sends you an alert with enough detail to know what you're dealing with and what to do next. And then the recovery component, which I've never seen offered anywhere else, provides financial protection in the event of identity theft up to $1 million. It's not just for money lost. That can be used for things like lost wages, legal fees, and other eligible expenses. So it actually gives you grounds to fight to get your identity back and undo all of the very real world damage that can happen from identity theft. Law Nerd, you know that one scam can cost you everything. So now is the time to get Coveron. Use code Emily Baker for 76% off at coveron.com/Emily Baker. And thank you, Coveron, for sponsoring this stream. Let's get back into it. All right. A huge thank you to our sponsors that let Emily go. It'll be a side quest. It's going to be amazing. And a lot of you asked in the chat if Coveron was the same thing as Incogni. It has the same removal features as Incogni, and then adds on the other layers of protection. But you can reach out to them if you already have Incogni, because it kind of bundles it together, because it adds that insurance component and can help pay for legal fees and stuff for recovery. So it goes beyond what's included in Incogni, but it is all under the Nord umbrella. And there are a lot of times where people ask, okay, Incogni pulls your stuff down, but then what happens next? And Coveron helps with that if it is a concern, including the insurance component that helps you pay for legal if you need to go fight identity theft, helps you recover things including lost wages if you need to take time to actually deal with the impact of identity theft or even cyber extortion and more. So there's a lot more there. It's like plus. All right. Are we ready to go to Massachusetts? Because I think we should. Let's do a quick road so far on this hearing and then go to Massachusetts. For anyone who might have missed previous hearings, I hope that will be helpful. Let's do that. All right. We are in the Karen Read multiverse. And we are talking about the wrongful death lawsuit. This is the lawsuit because of the defendant's greed. No, Emily, wrong lawsuit. This is a lawsuit that was filed by the O'Keefe family. Emily, that's not funny when we're talking about a wrongful death case. Like, it's a callback to the Toddy Westbrook days. No disrespect was meant. My brain was just like, back in the day, the first opening salvo of that lawsuit was like, I'm gripped, I'm set, let's go. But the O'Keefes, in kind of different configurations, have sued Karen Reed and the hospitality defendants, the bars, C.F. McCarthy's, and the Waterfall. The bars are sued under their corporate entities. So sometimes in court, you will hear the corporate entity names instead of their doing business as, like C.F. McCarthy's or the Waterfall or whatever. But the bars are also being sued. And it seems to me like the bar lawyers are just along for the ride. I have a hair that is making me crazy. This is why I always put my hair back. The bars seem to me to be along for the ride. The bars are like, okay, whatever, we're doing whatever. There are also a plethora of other cases, but in the wrongful death case, and I'm trying to kind of compartmentalize which cases are where, but in the wrongful death case, this one has been ongoing the longest, and the discovery deadline to have everything done closes in August. And so now there is a ramping up of all of the motions to compel. Remember, in Massachusetts, the motions to compel and the motion practice gets filed after it's done. So you have the party that's filing the motion serve the motion on the opposing party. The opposing party files their opposition. The filing party files their reply, and then all of them get filed to the court together. So you don't see a motion hit the docket, then an opposition, then a reply. Those get docketed all together in a group, which at first I was like, this is so odd. And now I'm obsessed and I want every court to do this because it keeps everything really cleanly together. Like, this is all of the motion practice, Your Honor, we're ready for you to consider it. I actually think it's kind of great. So I dig it versus like a motion hits the docket and then you wait for the opposition and then the reply. And in Utah, the court asks that you submit for a decision so the court knows that all the briefing is done. But in Massachusetts, they're like, here you go. I kind of love it. So we now heard on Wednesday. When did we do the last hearing? Tuesday, Wednesday? That more motions to compel were coming. A motion to compel is generally, hey, Your Honor, can you tell them to do this? Mom, he's touching me. Mom, they won't give me discovery. They won't sit for their deposition. They won't turn over their interrogatories. They won't respond to their requests for productions. They won't give us their documents. They won't give us their document in order. It's not tabbed. It's too many gigabytes. It's not enough gigabytes. It's tetrabytes. I don't know what kind of bytes it is. Motions to compel. Mom, can you make them do whatever is your motion to compel? And so we are now seeing the motions to compel discovery. And the one that we were in hearing on most recently was the motion to compel the deposition of Colin Albert. His attorneys have said, whoops-a-doodle, he's at basic training, boot camp, or like a course before boot camp. That wasn't super clear from the lawyer in the hearing. He was like, no, it's like a training before boot camp, but he's in boot camp and he's enlisted. There is still confusion about that because we have a lot of questions. And all of you that are in the military, as always, thank you for your service. All of you that are in the military are like, hey, girl, we have a lot of questions about this. This all seems strange. So the defense is like, he's completely unavailable. He'll be back in the fall. Bro, what do you mean you'll be back in the fall? The discovery cutoff is August. So the fighting between discovery has just been going back and forth and back and forth and back and forth and back and forth. The judge, in the way that he seems to do, is like, all right, everybody, Colin Albert's going to have to sit for a deposition. Y'all go away over the weekend, figure it out, and come back and tell me what we're doing. And remember, the lawyer who was fighting back and forth with Karen Reed's lawyer said, I'm unavailable that day, but somebody from my firm will step in. The person sitting behind me can step in. And they had a conversation about that. But it was those emails between Jim and Aaron that were so spicy. And then they're standing in court looking at each other. And I'm like, I will forever remain your obedient servant. A. Rose. I think I flubbed the line on that. Apologies. Emily, did you go see Hamilton over the weekend? I did. It was amazing. It was a great cast. They were fantastic. They were so good. Griffin was delighted. I was delighted. They were so good. I loved every minute of it. And then I cried a lot. I can't not. It's so good. It was so good. Love. But what's like sitting in a dark theater crying amongst friends, right? So these lawyers were going back and forth via email that felt very much like the fight. And I'm kind of sad that the other attorney's not going to be there for this hearing that we're watching, but I guess we'll see what happens. Because the fighting just, they're all so mad at each other. And it gives kind of the groundwork of the attorneys fighting. And then the questions of where is Colin Albert? Why can't he come back for a deposition? Does the military know? And it seems like this is something that they can accommodate. I mean, it's not as if members of the military don't have things they have to handle at home that come up, especially if they knew about this when he enlisted. There's a lot of questions. So we're going to go to the hearing. Thank you for no spoilers. I have not seen this hearing yet. I do not know what happens. And when I was saying the judge does what the judge does, this judge has just been like, fine, go back and then bring me an answer. He is now like micromanaging this case. And I think it's because this judge knows that discovery is very well not going to be done by August. And he has mentioned multiple times, when y'all are sitting before me asking for more time to extend discovery, we're going to have to just deal with this again. And keep in mind, this is the longest road so far ever. And keep in mind, this judge is also the judge that is handling the defamation case from the House defendants, including Colin Albert and Karen Reed and Turtle Boy. So when there was a fight over Colin Albert being a third-party witness, the rules are a little bit different with regard to the breadth of the discovery and things like that. But the judge reminded the attorneys at the last hearing, this was my interpretation, like cut the shit. We know that your client, Colin Albert, is a third-party witness in this case, but he's a plaintiff in the other case. And so we're going to have to do this at some point anyway. Like, okay, we doing this. We're going to have to do this discovery at some point. So even though Karen Reed's subpoena was breathtakingly overbroad, agreed, at some point we are going to have to do party discovery with these parties because they're all in the same defamation lawsuit. And the judge is like, let's be real. Yes, you're a third party here, but you're also a party there. And all of those cases are now in front of this judge. The case against MSP and Canton are not in front of this judge yet. And the federal case is not going to be before this judge. Cons the dog said, wait, so Colin is also suing Karen? Yes, in the defamation case. Colin is also suing Karen in the defamation case. He is one of the plaintiffs there, which had completely slipped my mind last time we were doing this. And then chat was like, girl. And I was like, oh shit, I had completely forgotten that. Completely forgotten. Let me pull that up real quick. So you can see now, of course, a plaintiff can drop out. This might change. We have not gone over the second amended or the first amended complaint, but it doesn't change the parties on the first amended complaint. But we have not gotten to the first amended complaint yet. It's docketed We'll get there. There's so much else going on, and there are going to be an extensive fleet of motions to dismiss in both the federal case and this case. I'm going to try to group all those together, so when we're talking about all the motions to dismiss, we can just do those kind of at the same time. But the defamation case is Jen McCabe, Brian Albert, Colin Albert, and Brian Higgins versus Karen Reed and Aiden Carney. And this case is now in front of the same judge that the wrongful death case is. So the wrongful death case and the defamation case are both in front of the same judge. The federal case where Karen Reed sues everybody for deprivation of civil rights and conspiracy and those things, that stays in federal court. That's Karen Reed versus Proctor, Telly, Buchanan, Jen McCabe, Matt McCabe, Brian Albert, Nicole Albert, all of them. That is in the federal case. Funny side note on that, the state court and the federal court both have motion arguments set on the same day for July 14th. So something's going to move because y'all can't be in two places at once, and it's all the same parties. It's all the same parties in their motions to dismiss in federal court and state court on the same day. But we'll get to that at the beginning of July. Today, we are going to go to court, and I am apprehensive because at some point, I feel like we're going to get to the point where I'm like, Your Honor, you have to put your foot down, because if you don't just make them do it, they're never going to do it. You got to just, at some point, you got to make the lawyers do the thing. Hold on, let me move this real quick. I was concerned there were going to be no cameras in the courtroom. They moved courtrooms yesterday, and then there was a feed set up that was going to stream it, and then it didn't. There was weird stuff going on. I'm so glad. I have no idea what this sounds like. Let's all just be thankful. I didn't think we would have any video of this hearing at all, and I'm so glad that we do. So no matter how shit the audio might be, I'm real thankful that we have anything, because I think we need transparency in these cases. There's too much that's gone on with the Proctor fuckery to not have transparency in these cases. And that's just the only option for me. There has to be. All right. So we are going to court for the continuation of the motion to compel Colin Albert's deposition that the court had continued because defense counsel said we only get to talk to Colin once a week on Saturdays. And the court goes, fine, go figure out what day he's going to be back here for a deposition, and then come back to court next week and tell me. And the lawyer said, okay, my colleague will stand in, but I'll be back in court. Fine. Let's fly to Massachusetts, shall we? Let's go to court. And let's go to court. This is the courtroom I think that the judge is normally in when we see him on Zoom with the books behind him. California's books were never like this lovely forest green. I'm vibing with it. It's a vibe.
00692, Paul O'Keefe, individually and personal representative of the estate of John Joseph O'Keefe III.
Yeah, this is the wrongful death case.
CNC Hospitality, LLC, doing business as CNF McCarthy's et al.
Oh, they're reading the whole
please state your name for the record because
title.
I'm plaintiffs.
Good afternoon, Your Honor. Dan Buck on behalf of the plaintiffs.
Good afternoon. Good afternoon, Your Honor. Aaron Rosenberg on behalf of defendant Karen Reed.
So Dan Buck is there, not Diller. Dan Buck's the one who's always kind of funny on Zoom. I like Dan Buck. If Dan Buck is speaking and not Diller, honestly, I'm not mad about it. But the plaintiffs are there even though this is not their motion. So we've got Dan Buck, and then Rosenberg is on the other side. Plaintiffs are the O'Keefe parties together.
Good afternoon.
Good afternoon, Your Honor. Sarah Shipley on behalf of the defendant, Karen Reed.
And good afternoon, Your Honor. Chris Maddie on behalf of non-party witness Colin Albert. I'd like to...
Okay, so the attorney that's there for the non-party witness Colin Albert is Chris Maddie. We saw him referenced on the email chains as well.
Thank the court for its consideration of allowing me to participate today, even though I'm pro hoc in on the defamation case and not on this one.
No problems. Without objection, correct?
Correct.
Dude. Emily, what does pro hoc in mean? It means that this lawyer is not a barred attorney in Massachusetts. There are rules for pro hoc vice. I think we've only seen pro hoc vice denied in a very limited handful of circumstances, and one of them was with Judge Canoni. This is not the person that was in court last time. That was Kieran. I forget Kieran's last name. But they are attorneys from another jurisdiction outside of the state, and they are pro hoc in the defamation case. Just pay the $350 and get pro hoc in this case too. But I can understand where they're like, well, but we're not parties in this case. We represent a third party witness. Like, I get it, but also if the cases are connected, I don't understand why the court can't say we've pro hoc'd this attorney. I also don't understand why the court can't just say we've pro hoc'd you in another case for this same party, because they've been pro hoc'd in to represent Colin Albert, and why they need to charge them to pro hoc in to represent a witness in another case. That seems kind of silly too. Why can't you just extend the pro hoc to this one too? It just seems silly. This seems like a silly roadblock when they're not a party, to not just overlap it. But again, all of you are like, but Emily, it's Massachusetts, right? You know what we know about the government that we can rely on? There's so little these days. We can rely on that they're going to get their money. That we can rely on that. They're going to get their money. They're going to get their money. Fair, it's Massachusetts. They're going to get their money.
Correct. Okay. So does the email you sent this morning, Attorney Rosenberg, to the clerk
There's a
reflect
new
the
email?
present status of the parties?
Yes, Your Honor.
Okay. And with respect to, you basically have two categories that are the subject of discussion, correct?
At least we can hear the judge. There's more emails?
Correct. The communications with the deponent's parents would be one category, and then the other one would be communications with others.
We're trying to narrow down the subpoena. Okay, we're trying to narrow down the subpoena. Fair enough.
Yeah, that's not exactly how we'd been discussing it last, but I see how you're saying that. Yeah.
Okay. And then in the email to Attorney Maddie today, or I don't know when it was, I guess it was on Friday.
Yeah, Friday, I think.
They were all supposed to talk on
referenced
Friday.
a date range of January 28th, 2022 through December 31st, 2023.
That's a narrow date range. So the first thing the court is addressing is the breadth of the Karen Reed subpoena that was asking for just all. It's like, can we have all from the last 4 years? It was broad. So now they are narrowing it down to January 28th through December 31st, 2023. I think the court's still going to find that to be a little bit broad. Though I think Karen Reed's attorneys could make a compelling argument that during Reed's trials, there might also be spikes of communication regarding this case based on that.
What category does that relate to?
So it would relate to both in part. So as you know, we originally had.
Just tell me.
Well, it would relate to for the non-parent category. Start with that. It would relate entirely to that.
Okay.
And then for the parents, there are two separate proposals we made. One was
A and B in the email.
Correct. So it would apply to B in that email as well. So it would apply to everyone.
I mean, I'd rather say the court is too loud. I turned that down just a little bit in case it's hurting anyone's ears. So hopefully that'll help. But they are, remember, part of the problem was that they wanted Colin Albert to come and do his deposition, but they wanted the document discovery before deposition, which makes sense. Like, hey, if there's stuff in there we want to ask you about, it doesn't make sense to have 2 depositions. Just give us the documents and then we'll do the deposition. Colin Albert's attorneys were like, we're not giving you all of this. It's way too broad. Karen Reed's attorneys are like, okay, I understand. We're going to have to go to the court and try to figure out what we're going to do for discovery, or we're going to have further conversations so we can come to some sort of agreement about what the discovery is going to be. We'll put over the deposition. And then all fuckery ensued. And now we're here. But the discovery needs to come first. However, they really asked for just like, yeah, just give us everything in your phone. And that's not going to work.
Okay, and then
So that's where we're at with the compelling the documents in depo.
are the communications that you talked about, the period of January 28th, 2022 through April 30th, 2022, which were a subset of the parent ones,
Correct.
are those limited by the which relate to language?
No, and there was a reason for that. So obviously one of the disputed issues, as you can see in the papers, is Mr. Albert's timing for being at and then departing 34 Fairview.
Which is going to be a key issue for them.
We believe that we're entitled to discovery that encompasses communications around that fact, and there could be, and I would imagine would be, communications in the immediate or close to immediate.
I gotta say, I enjoy Rosenberg's watch. Emily, are these the things you focus on in court? I mean, often it's the gift of ADHD, but I dig the watch. I'm an Apple Watch girly. I like, I need the reminders. I need my watch being like, hey girl, you need to stand up. But I dig the watch. It's a vibe. Continuing on. Skillet Pan said, Emily, do you have the vintage radio filter stuck on? It might have been recorded on a tin can. However, I'm very thankful we have a recording, so I'll take the tin can.
Days or months after
So I'll take it.
An event like this, between close family members, that would reflect those movements and would be relevant to those movements. However, we recognize that asking for every communication between a parent and their son can't be years. It can't even be the year, 2 years that we've limited ourselves to. So what we're trying to do is have a much smaller scope where we request all communications. Obviously, if there's attorney-client privilege or something like that, that is, they can make that claim. But we're requesting all communications within a very small period of time, and then the parents would be lumped back in with everyone else for the remainder of the period through December 31st, 2023.
And that small period of time is what?
Our last proposal was January 28th, 2022 through April 30th, 2022.
And
That's a narrower
why do you
period of
suggest
time.
It should not be limited to the issues otherwise identified.
Because let's just take, for example, that there's a communication about when you got picked up. That wouldn't relate necessarily to the categories that we have listed here, right? The death of Mr. O'Keefe, the investigation into Mr. O'Keefe, I would say it's relevant, obviously, but you could see communications about timing, who was driving, how they knew to go pick you up, etc. I'm just giving you examples now, but things that would not otherwise fall within that category. And we're not asking for that with everyone, but we are asking with.
And that's similar to what we were saying together last time when we were talking about, look, the attorney for Colin Albert wanted to narrow it down to conversations relating to the investigation. And we had all sat here and said, well, that's maybe too narrowly parsed, because what does relating to the investigation even mean? Is it just them saying, hey, did you see law enforcement was at the neighbor's house, or hey, did you get called for an interview, or hey, did so-and-so talk to so-and-so about this investigation? And I understand Rosenberg's point on that. That narrows it down too much, because there are conversations about what happened that night that aren't conversations about the investigation. And so this is basically what we had discussed together, that they are, Reed's team is asking for like everything and narrowing it down. And the witnesses' attorneys are starting with, you'll have nothing and be happy, and then having to expand it from there.
As between Colin and his parents.
You don't believe there's any way to limit the scope of that request to other than all?
I mean, can't you have like a discovery mediator? That's not the right word, but you can have a discovery referee. That's the word I was looking for. You can have a discovery referee if this is going to be that kind of a problem, and just say, fine, you don't want to turn it all over, we'll have a discovery referee. However, the expense of that falls to the parties, but also Colin is suing Karen Reed in another case. So are some of these hoops that don't need to be jumped through? Because at the end of the day, we're going to end up right back around to this all being turned over.
We could try to limit it to, say,
Well, I take it if you haven't communicated since Friday afternoon, you haven't been trying, right?
well, as you saw in the communication, I haven't been trying, correct? Because I made a final proposal on Friday that you just referred to, and the response I got was we're comfortable with our last proposal.
Let me hear.
So where are we at the end of the day Friday then? From Karen Reed's attorney Rosenberg, it's, well, we made a proposal to them, and instead of continuing to try to compromise, they said, no, we're good with what we said last time. We said what we said and we're not doing anything else. So is there any more room to discuss that? I don't know. You tell me, is there any more room to discuss that? We're offering A. Okay, well, we offered Q. Okay, well, can we come between those two? No? Okay.
Attorney Maddox.
Yes, Your Honor, and I'm maybe at a bit of a disadvantage because I don't believe I was copied on the email correspondence this morning, and if I wasn't, if I was, please correct me, Attorney Rosenberg. But I don't think I was copied on.
Yeah, that's my fault. Your co-counsel was. I apologize.
I'll tell you what, it'd be helpful if you.
Oh. Rosenberg's like, oh yeah, sorry about that. Your co-counsel was. Because co-counsel was the one he had been talking to. Like, I get it, but also can we just CC everybody on it?
You went and familiarized yourself with it, so why don't we get a copy?
Yeah, here, you can.
Right? We'll take a short break. You didn't have to read it in front of everyone.
But it was just forwarding.
We'll take a short break and let you read that so you're up to speed like everyone else is.
Thank you, Your Honor.
All right.
All right.
Oh, whoever on the community TV that put this video up and edited out the break, doing the Lord's work out here. Everybody got email problems. Everybody got email problems. However, he was not the one engaging with this at the last hearing. It was the other attorney. And then he said, Kieran will be the one that will be here for me on Monday. So I don't know if this is Rosenberg's bad or if they didn't tell Rosenberg that it wasn't going to be the firm that the last guy is from. Because I think that Maddie and Jim and Kieran are from different law firms. But I'll double check that while we're listening. Is the judge going to get mad at them for having two different law firms representing them too, or nah?
I did, Your Honor, yes. And it was just a transmittal email that included the rest of our correspondence, so I'm comfortable with that.
Okay. So what do you say to whether or not
So the break wasn't needed, Your Honor?
Scope of the request for that limited time period could be reduced from everything to something less?
Yes, Your Honor. Our proposal, which we made to defense counsel, we thought was quite broad and actually should capture.
And yes, Jim Tuxbury and Kieran are from a different firm than Christopher Maddie. I pulled this up off of the civil case. Jim is at a firm that's in Boston. Kieran is from same firm, but the office in New York. Maddie is from a completely different firm in Connecticut. So we've got like the Eastern Seaboard represented. So there we go.
Information concerning, for example, Mr. Albert's movements on January 28th. What we suggested was that...
Well, they didn't take it that way, I guess, right?
Well, they may not have, but what we suggested, and perhaps the court, you can tell me if you think this is fairly broad in scope, but what we've suggested is...
Right now, it doesn't matter what I think. What matters is what...
Can you all sort it the fuck out? The question is, where, when, and who knew? Those are the questions. Where, when, and who knew? The court's like, I don't care. Y'all need to figure it out and do discovery.
The two of you think and what you can agree to.
Yeah. So our belief is that anything that Mr. Albert may have, any communications or documents that he may have relating to the facts and circumstances of Mr. O'Keefe's death or the law enforcement investigation into Mr. O'Keefe's death would encompass any responsive material that would be relevant to this matter. And we're willing to do that. We're willing to do that for a 3.5-year period. And we're willing to do it with respect to every individual that they've asked for communications to or from. And so this, to me, is a little bit of a situation where Ms. Reed won't take yes for an answer. We're actually agreeing.
But can you see where the concern is? Can you see where I can see where the concern is? What's a conversation about the investigation versus what's a conversation about where you were? I can see what the concern is. Because the concern is the lawyers are going to be like, well, no, they're not talking about the investigation. They're not talking about law enforcement. Reed's team wants to make sure that we're not playing games with what are we saying about this night. And this is par for the course with civil. The definitions of everything matter. And one party is going to seek for the broadest possible definition, and the other party is going to seek for the narrowest possible definition. And so they're saying, well, we're saying we'll turn it all over, the communications regarding the investigation. Do you think that a fair reading of communications regarding the investigation includes communications about the night of John O'Keefe's death, or communications about law enforcement the next morning and who's investigating and who's being interviewed? I can see where the fight is.
To provide anything that we may have relating to the facts of John O'Keefe's death, which is the central issue in this case, or the investigation into his death, which, as I understand it, would encompass what Ms. Reed has claimed is a false narrative surrounding, what the plaintiff would claim is her false narrative surrounding that death. So we are comfortable that frankly, that we've kind of bent over backwards to include a 3.5-year time period of two very broad categories. I offered to discuss search terms with counsel that we could agree to in order to come up with materials that might be responsive. And so, for example, if counsel felt that the category we've suggested would not encompass the timing of when Mr. Albert left 34 Fairview, the way around that is just to agree to a search term that would capture those communications, because we have no objection that those would be responsive and within the category we've suggested.
Then why couldn't y'all come to this understanding on Friday?
But what we object to is a unscoped request for materials, particularly relating to communications he may have had with his parents, and the very, very broad categories that seem designed to capture information that is not relevant to the issues in this case, which, as I understand it, are one, the facts and circumstances surrounding Officer O'Keefe's death.
Hang on.
Yep.
Give him a chance to respond.
Yes, sir.
You think it?
Yeah, I'm actually going to address what I think Mr. Maddie was about to address. This case isn't just about what happened to John O'Keefe. That's part of the wrongful death claims that the plaintiffs have alleged. But as your honor's aware, they have these false narrative, intentional infliction of emotional distress, negligent infliction claims, which relate to.
Rosenberg is projecting so much that I'm going to have to turn this down just a little bit. So that's me.
As they call it, the false narrative. That includes the investigators, the investigation, and what Ms. Reed said in both her criminal trial and her other statements that something happened to Mr. O'Keefe within the house. That is the false narrative. So it can't be limited to just the death of John O'Keefe. I'll give you one example. If Colin Albert had sent a text about Karen Reed, but not about the death of John O'Keefe
or
and
the
specifically the
investigation.
circumstances, I believe that's well within the scope of discovery in this case, and it would be excluded by what Mr. Albert's counsel has proposed. Similarly, if Mr. Albert said something about his relationship with investigators, which is a main part of that quote-unquote false narrative in this case, and that Mr. Albert himself is suing Ms. Reed about, that necessarily wouldn't have been included. So it needs to be broader. I'm more than happy to work on search terms with Mr. Albert's counsel. In fact, I think that's a very efficient way to do that. But we need to either agree on, which we haven't been able to, or establish through your honor what the scope and the categories that are rightfully at play here are.
And the thing is, everybody's real feisty over email, and then they're in front of the judge, and now they're like, well, we could agree on search terms. And they're like, news to me. Great. Can we do that now? So, you know, if you could just get it done over email, it would be great. But it's a totally different vibe once you're in front of the court, which is, I think, why the court keeps bringing these parties back in front of the judge again and again and again. At some point, Your Honor, you should have just appointed a discovery referee. Because there's so much.
I'm more than happy to work with them on search terms immediately to get to those categories. But I think you can hear that we've still got differences here. And this is not unscoped. You can see we proposed terms. We limited it from the subpoena. There are specific topics that we're asking for, not even of everyone, but only of certain individuals. And those topics are Miss Reed, Mr. O'Keefe, the investigation, the state police and Canton police, the Norfolk DA, and the U.S. Attorney or DOJ. That's not everything under the sun.
Those are
to the extent there are categories or individuals where Mr. Albert.
And so this is where Karen Reed's team is saying, look, limiting the search to conversations about the investigation doesn't always get us there. So we should broaden that to conversations about Karen Reed, conversations about John O'Keefe, conversations about the investigators, conversations, I think, about the trial, which would encompass Karen Reed. So they're fighting over what discovery they're going to get in document discovery before they even get to a deposition.
Has none? As I've
I interrupted in the middle of his sentence.
And the U.S. Attorney or DOJ. That's not everything under the sun. And to the extent there are categories or individuals where Mr. Albert has none, as I've said repeatedly, we will accept that. If counsel represents there were no documents as to, individuals A through D, then we're done with those. And additionally, if there was some extreme burden, right, there was one term or subject matter that was bringing back thousands of messages and it was going to be burdensome in order to go through and produce those, we would have considered that. But we haven't heard any of that in the communications or in the multiple hearings we've now had. It's just this overall, this is too broad. And we heard, Your Honor, about the time scope. We cut it more than in half. We addressed the terms, but at a certain point, we're entitled to the discovery that we're seeking pursuant to our subpoena.
May I respond briefly, Your Honor?
Absolutely.
So, on the false narrative claim.
So today the court's allowing today the court's like, let us hear you out. Judge is in a totally different mood today than he was last week. He's like, sure, let's all hear it out. Let's all hear it out. Okay. let's see what everybody has to say. And what they keep talking about is that even though I refer to this as the wrongful death claim or the wrongful death case, there are other causes of action in the wrongful death case. And so as they keep bringing up and calling it the false narrative causes of action, there are negligent infliction of emotional distress causes of action here. And so what they're discussing are those negligent infliction of emotional distress causes of action that are about things Karen Read said after the death of John O'Keefe and through the filing of the lawsuit. And the wrongful death lawsuit was filed back in August 2024. So it's because this goes beyond just being a wrongful death case, which is what Rosenberg keeps saying, is we're not just defending a wrongful death case, we're also defending the negligent infliction of emotional distress causes of action.
What Ms. Reed apparently wants to present as a defense in the wrongful death case to the emotional distress counts is that what she said was in fact true. Or whatever she claims happened.
Or it wasn't negligent. This is lawyer parsing, but I don't think she has to prove necessarily that it's true. I think she has to prove that it wasn't negligent to say it. And I think a jury can evaluate that in the context of a criminal case for the things she said after she was charged. Because I think that might shift the way a jury sees that. Because it's not just these statements were being said like out of the blue, like the TikTok psychic case. It becomes in the course of a criminal prosecution, what is she seeing and what does she believe? So it goes in the infliction of emotional distress. It's different than in a defamation claim. Does that make sense? And that is part of where this is different than the defamation case. So it's not, I think they're going to try to prove truth, but they don't have to. It's not truth or falsity. It is whether her statements were negligent in that she was disregarding the emotional distress that it would cause the other parties, because it's not a defamation cause of action. And it'll be interesting to see how these things get argued when this gets to trial, but I imagine we are going to see some arguments that from Karen Read's side, that the distress caused by the death of John O'Keefe stands aside, and that Karen Read fighting this investigation, they're going to argue isn't a negligent infliction of emotional distress because the distress had been caused by the death, and that the negligent investigation is what is really causing the further distress. I think we're going to see some of those arguments when this gets parsed down into that. So let me back up. I interrupted the other lawyer as they're fighting over negligent infliction of emotional distress. If y'all, this is not a today ask, this is a as EDB plans for the future ask, would it be helpful if we go through what negligent infliction of emotional distress looks like in Massachusetts? We haven't done that in quite a while. We talked about this a lot more when we were looking at the Laundrie Petito litigation, because then we were looking at intentional and negligent infliction of emotional distress in Florida. But we might need to take a minute. All of you are saying yes? Okay. I'm going to put it on the docket. And I think what we'll do down the road is take a look at the cases altogether of all the parties suing each other, and take a look at the differentiation between the defamation causes of action and the infliction of emotional distress causes of action, and kind of pull those out, because the malicious prosecution, those all kind of stand to the side a bit. But when we're talking about defamation and infliction of distress by things that are said, I think we can look at those things together, because they're all going to be before this judge, and then parse the law on those. So that might help. Okay. All of you are like, that would help. All right. We will set aside a day to kind of take a look at what's going to need to be proven in these two different cases and where the different kind of word crimes fall, because they have very different standards. Okay. Sounds good, chat. Chat is bay. Let's back up. This is why they're arguing over those causes of action.
What Ms. Reed apparently wants to present as a defense in the wrongful death case to the emotional distress count is that what she said was in fact true. Whatever she claims happened inside the house, to the extent there's any evidence at all that she is at some point going to present to this court, then that would be captured by precisely what we've proposed, the circumstances surrounding John O'Keefe's death. So let's just take a parallel universe where
we're already in a motherfucking multiverse. Can we not take a parallel universe? We are in a multiverse of litigation.
Mr. O'Keefe, as Ms. Reed alleges, went into the house and something happened there. If Mr. Albert has any documents relating to that parallel universe, it would be captured by exactly what we proposed.
That's
because what
the problem.
we are proposing to do.
But that's, do we see the parsing?
Is to provide any documents.
Other people's parsing.
Alleges went into the house and something happened there. If Mr. Albert has any documents relating to that parallel universe, it would be captured by exactly what we proposed. Because what we are proposing to do is to provide any documents, any communications concerning the circumstances surrounding John O'Keefe's death. So that's number one. With respect to their claim that they should be entitled to any communication.
But I can see where the argument is. They're saying, hey, we will provide anything surrounding or about the circumstances of John O'Keefe's death. You tell me, if you were trying to craft, we're going to arguendo, chat, get ready to get uncomfortable. I want you to put yourself in the mind of Colin Albert's lawyer. Work with me on the intellectual exercise for a minute. And if you are Colin Albert's attorney and you are stepping into that role as a zealous advocate for your client, I know. It's okay. It's uncomfortable. Not like the backseat of a Volkswagen, different kind of uncomfortable. And you are trying to turn over only responsive documents. And you are turning over things that are responsive to the query of communications around the circumstances surrounding John O'Keefe's death. Would you find that a conversation about when Colin Albert got picked up, went home, who knew, what time he got home, would you argue that that is about the circumstances surrounding John O'Keefe's death? Or would you argue that that's not communications around the circumstance of John O'Keefe's death? Because I can see the argument that what time he left isn't about the circumstance of John O'Keefe's death. I can see them arguing that down the road 100%. Yeah, but what time he left isn't about the circumstance of John O'Keefe's death. It's about how he got picked up. Because how would you define the circumstance of John O'Keefe's death? If he got punched, if he got pushed, if he fell, if he was in the house, if all of those things. So they're arguing, hey, we're going to turn everything over. And then they're narrowing it by, well, concerning the circumstances surrounding John O'Keefe's death. But you see the argument? So this is where the attorneys are arguing over what encompasses what. And that's why it's a big deal. And that's why we're here. So.
Communication about Miss Reed.
They're also saying, and yes, we'll give them communication about Miss Reed. But is Colin Albert's communication about what time he left the house about Miss Reed? No, not at all. Right.
So that's number one. With respect to their claim that they should be entitled to any communication about Miss Reed, Mr. Albert was and is a victim in a criminal case that's been brought against Aiden Kearney that, as I understand it, Miss Reed was at one point a subject of as well. She was not charged. But I'm highlighting this as an example of why Mr. Albert might very well have communications about Miss Reed.
Your Honor, they're talking about Miss Reed, but it's not relevant because he's a victim in another case. And he's also suing Aiden Kearney. So this is all going to come up anyway because he's suing in the defamation case. You're just trying to stagger when the shit comes out of the horse at this point.
That have nothing to do with the issues in this case. They would want us to produce a communication in which Mr. Albert pointed out that Miss Reed had a dog or a cat, which has no relevance to this case. Or that Miss Reed...
Does Karen Reed have a dog or a cat? Are there pets involved? Other than Chloe? Are there other pets? Also, what's the problem of turning over Colin Albert saying, well, does she have a dog? Because if it's not relevant to come in at trial, then you fight it then.
Had launched a defamation campaign against him, which also has no relevance to this case. It may have relevance to some other case, but it has no relevance to whether or not Mr. O'Keefe, the circumstances surrounding his death, which again, we agree. Anything relating to that, they should get. Anything relating to the false narrative claim, which again, has to do with the circumstances surrounding John O'Keefe's death, they should get. We've agreed to give that to him for a 3.5 year period. So I'm not understanding yet.
Rosenberg, for those of you listening in the background, Rosenberg keeps thinking bro's done with his sentence and he keeps going. So he's like waiting to get up and respond. And you can see him just kind of, he's like clicking the pen and taking notes and bouncing in his seat, ready to respond because he thinks bro's done. That's funny. I'm going to rewind that real quick because I got distracted by Rosenberg sitting there like a jack in the box. I'm just when we get to the arguments over what's been turned over and the inevitable argument that things have been rehomed and that things don't exist, just remind me of all of this when we get to those arguments, because I am concerned that we are going to spend a lot of time together and a lot of court time going around and around and around and around and around about the search terms. And then they're going to turn around and say, oh, the only text he has that's responsive is this one screenshot of this one text. Everything else is just gone. I have concerns that that's where we're going to end up at the end of the day. And we are going to spend so much time getting to, whoops-a-doodle. There's nothing there. I have grave concerns.
They should get anything relating to the false narrative claim, which again has to do with the circumstances surrounding John O'Keefe's death. They should get. We've agreed to give that to him for a 3.5 year period. So I'm not understanding yet why the very, very broad scope,
we got it,
which I think counsel would acknowledge, would necessarily result in communications that are not relevant to anything here. Why the court should bless something like that when what we've proposed, I think, broadly encompasses all of the claims in this case.
Just 2 quick points. One, the false narrative is not just about the death of John O'Keefe. The part of that alleged false narrative is the cover-up and conspiracy side of things. That necessarily came after Mr. O'Keefe died. So it's inaccurate to say that we can capture anything relevant to this case by stopping on January 29th, 2022 or thereabouts. Secondly, as we're all aware, this is a third-party subpoena. At a certain point, a third party is not in a position with standing to argue about specifics of relevance. They have standing to argue about burden and undue burden on a third party. And we recognize that, and that's why we made changes. But a relevance objection like this is misplaced at this point. We are entitled to put document requests that, in a subpoena that are reasonably intended to gather relevant topics. I think a term that relates to communications about Karen Reed and about John O'Keefe is well within that scope, as Rule 26 uses the phrase relevance.
I'm not trying to get the last.
Counsel, if you're going to say, I'm not sure I get the last part, Rosenberg's point is, y'all want to come in here saying we're a third party, we're a third party, we're a third party. He's like, fine, then your only arguments are unduly burdensome. So you don't get to argue that it's relevant, that it's not relevant. You get to argue that it's unduly burdensome. So if you want to be a third party, fine, you're a third party, but then you have to abide by the fact that you don't have standing to argue, according to Rosenberg, relevance. Only burden. All right. Continuing on with this attorney.
Word, Judge, I just had a couple of things I wanted to add.
Of course.
Afternoon.
And the judge is like, who is this judge today? Today the judge is like, I had a 3-day weekend. I got nowhere to be this afternoon. The weather's too hot to be outside. So I got all day. We'll do this shit all day. The court is so unbothered today. Half the time he's just like, no, we're not talking about this today. Today he's like, yeah, give me all the tea. What's up? All of you are like, he had a good lunch. Must have been. He's like, sure. Let us away. His calendar must be done for the day. He's like, we're good. I don't have anything on calendar tomorrow that I need to prep. Let's just go.
What she's claiming.
All right. I interrupted counsel.
I'm not trying to get the last word, Judge. I just had a couple of things I wanted to add.
Oh, I'm not trying to get the last word. Technically, Karen Reed's party should get the last word because it's their motion, but whatevs.
Relevance.
I'm not trying to get the last word, Judge. I just had a couple of things I wanted to add.
I got all afternoon.
Yeah, he said I have all afternoon.
First, if what she's claiming is that there was a grand conspiracy and a cover-up, okay, the date range we have proposed, to the extent there were any communications in furtherance of this conspiracy and cover-up, would more than act.
Sir, 10 out of 10 on being slick. Like, I get where you're at, but do y'all see what just happened? Emily, what are we doing today? Today we're just evaluating lawyering. That's it. Today we're just evaluating lawyering. Do you see what happened? Karen Reed's attorney got up and started talking about search terms and said, we've narrowed down the scope, but we think that conversations about Karen Reed are important. These conversations and these search terms are important. And he switched back to talking about date range. Hey, Your Honor, we've narrowed down the date range. They have not responded to the search terms that Rosenberg's talking about. He keeps jumping back and answering about the date range, which seemed to already have been agreed upon. Hello said lawyers are horrible lawyering. Oh no, this is not horrible lawyering. It can be frustrating to watch, but he's bridging to the argument that he wants to continue to make. He's not answering back to the point that counsel made. He's continuing to shift the dates. And that matters. Pesky Pirouette said, is Tuxbury still talking? Not Tuxbury today. This is Mattei, Mattei. This is the lawyer on the case from Connecticut, not Jim. Christopher, Mattei, Mattei, Matty. Yeah, not Tuxbury. So we're getting we're getting the slight shifting in the arguments of that. Allie in Texas said, shouldn't Maddie have reached out to Rosenberg and colleagues after not hearing anything all weekend? He wasn't on the communications, but also he's not the lawyer on this case, and he's not the law firm that appeared in court. So no, Chris should have reached out to Jim and been like, hey, Jim, if I'm standing in for you in court on Monday, what's going on? That's a conversation between Christopher and Jim, because where we left this, when we were last together, on the last episode, it ended with Jim saying that Kieran was the one standing in. And so why would anybody loop in the lawyer from a different law firm from Connecticut when Tuxbury said it would be Kieran, who's from the same law firm, just from a different state? So, continuing on.
Quickly capture them. We're proposing a 3.5.
Karen Reed's attorneys are like, but Your Honor, we've narrowed down the dates, the search terms. Colin Albert's attorneys, but Your Honor, the search terms are fine, but the dates, they're just, yeah, they're just islands in the stream at this point.
Is that there was a grand conspiracy and a cover-up, okay? The date range we have proposed, to the extent there were any communications in furtherance of this conspiracy and cover-up, would more than adequately capture them. We're proposing a 3.5-year period. And so if, as Ms. Reed apparently
other people's period
purports to believe, there was a grand conspiracy that was occurring in 2022 and 2023, and there were communications about the circumstances of Mr. O'Keefe's death at that time, and the fact that all these people, dozens and dozens of people apparently were conspiring, then those will be produced in this case under the subject matter that we have scoped here.
Rosenberg's just shaking his head at counsel table.
I also just, on the relevancy thing, we've cited authority in our brief, Your Honor, that the party propounding the discovery has the burden of showing some relevance.
They have.
And so this is absolutely an issue that
they think they have
to decide when considering what is an appropriate scope here. Obviously, you don't have to decide what information and evidence may be admissible or not. That's not the issue. But the reason that that inquiry about relevance exists and is important for the court to conduct is because otherwise parties would engage in fishing expeditions all the time, which I know this court doesn't want, we don't want.
I think they've shown why
which
it's
Ms.
relevant,
Reed
but
seems to be seeking.
They think it's a fishing expedition.
One example of
the first subpoena was way too broad. However, is that uncommon? No. It's a jumping off point for negotiations, which is what was supposed to happen over the weekend. Back to Rosenberg.
Of something that would not be limited to the about circumstances of Mr. O'Keefe's death. There are allegations that Ms. Reed has made in multiple lawsuits, including this one, that certain of the individuals in the house deleted phones or deleted contents of phones or devices. Mm-hmm. That obviously happened well after Mr. O'Keefe's death. If there was a text, and I'm not saying it exists because we don't know if it does, but if there was a text between Mr. Albert and someone else who was in the house that said, get rid of your phone, that would be very, very, very relevant to the alleged false narrative claims and the conspiracy that Ms. Reed has alleged, and it would absolutely not be covered by the circumstances surrounding Mr. O'Keefe's death. There are plenty more, but I think that highlights the concern.
So they say it's included, you say it isn't.
Well, they say generally it's included, but if it were included, if the answer was...
They didn't really say it's included. They said it should be. They didn't really say it was included. They said, well, it should be.
It's stated on the record.
And the court's saying, well, they say it's included, so why do we need to keep fighting about it? Because they're going to try to figure it out now rather than come back and fight about it later.
They say it's included, you say it isn't.
Well, they say generally it's included, but if it were included, if the answer was...
It's stated on the record in two areas that they're going to produce what you're looking for.
Right, but as your honor is aware, it's not our job to give them the specific examples of documents that may exist in their client's possession, custody, or control. It's our obligation to give them a sufficiently limited amount that it doesn't impose an undue burden on them, but categories. And that's what we've given. They've taken those categories and significantly narrowed it. And I recognize that Mr. Maddie, and I believe Mr. Maddie, that the two examples that he's commented on today, he says would fall in their narrow, very narrow categories, and that's great. But I think there are tons of other things that would be very relevant that would fall well outside that, and I don't think that's proper.
So what is Rosenberg arguing with the court? The court says, well, they say that those two things are included. And Rosenberg says, right, but those are just two examples. We don't know what we don't know. And we need to make sure that these categories will include everything. And we're not sure that it will. So even though they've said, well, that one example would count or this one example would count, doesn't mean that the categories are going to be broad enough. And I understand the concern from Rosenberg's side. And I saw a couple of you ask about why does Colin Albert's attorney keep referring to Reed's side as the party? Reed is requesting it's appropriate to do so because the party is the one that is propounding things through the lawyer. So we see it in criminal cases too, where it's referenced that the defendant is seeking this. So it's not inappropriate to say, Reed is requesting this or Reed is requesting that. Same with if Reed's attorney is saying, well, Albert is doing this or doing that. So, right.
Anything else?
No, thank you.
Anything else?
So, anything else on the issue of the document discovery? And both sides have said no.
Not on this. I just wanted to briefly update you about a different motion. Are you?
Hey, Buck, do you want to jump in? Or
No, I'm sorry. Just one other.
Mark, stay seated.
Yeah, I don't want to be well enough.
I don't want to steal Attorney Buck's thunder. There is the outstanding issue, Your Honor.
Anything else on the document discovery? No. Okay, but what now? Well. Anything else? No. Well.
About Mr. Albert's availability for a deposition. I know we've started discussing the scope, and so I'm happy to discuss that whenever it makes sense for the court.
Go right ahead.
Okay.
Do it now.
Your Honor, since last week, we have made inquiries of the United States Army at Fort Jackson, and we've also done some research about how a deposition of an active duty.
Have you talked to Colin Albert, though? Because your colleague at the last hearing said, I'll talk to Colin Albert on Saturday. So I want to know if y'all talked to Colin Albert.
Whenever it makes sense.
All right, so here we go. We're going to be talking about Colin Albert's availability for deposition. I'm very curious to see what happens. So I backed him up just a little bit.
To the court.
Go right ahead.
Okay. Your Honor, since last week, we have made inquiries of the United States Army at Fort Jackson, and we've also done some research about how a deposition of an active duty service member would be arranged. And bottom line up front, Mr. Albert, as a...
Is he active duty? I don't know when that counts. But they are saying he's active duty. I just don't know when that counts. But why are we doing research and not talking to your client?
Trainee in the United States Army is under research about how a deposition of an active duty service member would be arranged. And bottom line up front, Mr. Albert, as a trainee in the United States Army, is under the command and control of his commanding officer.
Right.
And so if Ms. Reed wishes to take his deposition, yes, sir.
Just curious.
trainee and active duty don't sound like the same thing, but I have questions. So now the court's interjecting.
To take his deposition. Yes, sir.
Just curious, did your research include a subpoena that already was served?
Well, you're.
Oh, boy. Oh, Your Honor. The judge is like, excuse me. I don't care. I don't care about your research. It's already been served. I don't give a shit. I had to back that one up. That's funny. That's funny, Your Honor. We're backing that up.
Albert, as a trainee in the United States Army, is under the command and control of his commanding officer. And so if Miss Reed wishes to take his deposition. Yes, sir.
Just curious, did your research include a subpoena that already was served?
Well, Your Honor, so I guess the question you're raising is, if Mr. Albert had been served with a subpoena.
No. Nope. I appreciate your reframing. It's Olympic levels of reframing. It's so fluid, the reframing. No. The court decided last week that it was still a valid subpoena based on everything that the court said. Did he expressly rule that? No. But the court, in everything the court discussed last week, the court operatively said that that is a served and still valid subpoena. When he told your colleague, Colin Albert's going to have to sit for a deposition. The court was saying within that statement that yes, it's a duly served and still valid subpoena. So that was decided last week, counsel. You might have missed it, but that was last week.
Subpoena that already was served.
Well, Your Honor, so I guess the question you're raising is, if Mr. Albert had been served with a subpoena.
She had been.
Correct. Prior to entering the military. And let's presume for a second that subpoena remains valid, even though I know you know we take a different position.
The court's already determined that. Emily, keep reading. The court interjected there. If he's been served, the court said he has been. He has been. Right.
And he then.
So.
Prior to entering the military. And let's presume for a second that subpoena remains valid, even though I know you know we take a different position. And he then enters the United States Army in the interim. The United States Army has custody of his person. And so if the deposition is going to take place after the date upon which it was originally scheduled, April 29th, I think, then the only way for that deposition to occur is with the consent of the United States Army. And there's a process for that. What would happen is Attorney Reed's counsel, Miss Reed's counsel, or we could help facilitate this process, would reach out to the staff judge advocate at Fort Jackson and let them know that there is a request for a non-party in civil litigation pending in Massachusetts.
Why is this their problem when he was served before, though? Did you notice that he kind of navigated in there? I mean, we could help with this. Why is this the other party's problem? Why isn't this your problem?
To take Mr. Albert's deposition. And I've never done that before, so I don't know exactly how that process would play out, but I know that would be the necessary first step. Now, I've called the staff judge advocate 4 times at Fort Jackson between last week and this morning. I've left 4 messages. I haven't heard back. I've also consulted with a colleague who's a former JAG officer with 2 combat deployments. She advised me that
I mean, I appreciate your colleague who was JAG, who had 2 combat deployments. Thank them for their service. How does this have anything to do with when Colin Albert's going to be available. Like, yay for co-counsel, but also what does it have to do with the question that the court asked you last week was, when is Colin Albert available? Your Honor, we can talk to him on Saturday. You've done a whole lot of conversation around not answering that.
4 times at Fort Jackson between last week and this morning. I've left 4 messages. I haven't heard back. I've also consulted with a colleague who's a former JAG officer with 2 combat deployments. She advised me that the process would definitely include the staff judge advocate at Fort Jackson, may also include the Army Litigation Division, which is the main legal component of the United States Army, and that process would just have to play out.
When did you talk to
your client? But the reality is, neither we nor Mr. Albert have any authority to present him for a deposition while he is in basic training. He's not given any leave. He's not given any visitation at Fort Jackson. He has very limited access to telephone. His day starts.
I'm curious whether the court would grant the motion to compel, set a date, and then have a contempt hearing on it and be like, you knew about this before. This is not a me problem. This is not a them problem. This is a you problem. You knew of the subpoena obligation. And so I'm going to grant the motion to compel the deposition. I'm going to set a date that it needs to be done by. And if it's not done, then we'll hold contempt proceedings. I don't know if this court will do that, but this is going to get real messy. It's going to get real messy. I've never seen this issue come up in a case before. So for that, I guess I'm grateful. But this is going to get real messy.
It's at 4:30 in the morning.
They have limited access to talk to him. Right. You were supposed to talk to him on Saturday.
United States Army. And that process would just have to play out.
I had to back
But the reality is, neither we nor Mr. Albert have any authority to present him for a deposition while he is in basic training. He's not given any leave. He's not given any visitation at Fort Jackson. He has very limited access to telephone. His day starts at 4:30 in the morning, ends at 9 p.m., and it's entirely structured. And the basic combat training program is phased, so that phase 2 builds on phase 1, phase 3 builds on phase 2. This is a 10-week program, after which we understand he will be granted leave. And so what I asked counsel last week was...
Last week it was a 3-week program, then a 10-week program. This week it's a 10-week program. I still don't know. But what is clear is that none of this is a problem for the other side. This is a problem for you. And the discovery cutoff is the discovery cutoff. How is he going to do depositions as a plaintiff in another lawsuit, though? The conflicting information about this has been curious.
Listen, if Judge Gilday were to permit, given the burden that forcing Mr. Albert to submit to a deposition while he's in basic training would impose, if Judge Gilday were to permit an enlargement of the scheduling order for the sole purpose of conducting this deposition after Mr. Albert completes basic training, and if the other defendants, if the other parties agreed to that, would you? And they said no. And I asked them why.
Okay, I'm gonna have to back that up. My brain got focused on something else and I lost his train of thought, but my train of thought was, do you see where the problem is? Because I think they are setting up a separate argument in addition to we can't physically produce him for deposition. I think the follow-up argument after we get to, oh, he can be available for depo on this date, what's the next argument? We've had no time to prepare our client for deposition. We've had no time to discuss with our client. Limited access to phone, no visitation. We can't prep him for his deposition. So even if they can make him available for a depo date, we haven't had enough time to prepare our client for depo. I think that's going to be the next argument, but we'll wait and see where he goes with this.
This is a 10-week program, after which we understand he will be granted leave. And so what I asked counsel last week was, listen, if Judge Gilday were to permit, given the burden...
Who are you asking? Why we have hearsay in this argument.
This is a 10-week program.
Sorry, I'm so confused about why he's talking about the judge as if he's not talking to the judge. It's just my brain is having a hard time following him.
After which we understand he will be granted leave. And so what I asked counsel last week...
What he asked Rosenberg. Sorry, I got lost in what he was talking about. That's on me. So what he asked Rosenberg... So this is the conversation they had about this last week.
Was, listen, if Judge Gilday were to permit, given the burden that forcing Mr. Albert to submit to a deposition while he's in basic training would impose, if Judge Gilday were to permit an enlargement of the scheduling order for the sole purpose of conducting this deposition after Mr. Albert completes basic training, and if the other defendants, if the other parties agreed to that, would you? And they said no. And I asked them why, and they said they had strategic reasons. And what it made me wonder is why they...
What are the chances that he watched the hearing where the judge was all mad about the strategic reasons and that's why he's bringing it up? I'm just curious. But what he is saying is that in his conversations with Rosenberg, he asked if the judge will allow for an embiggening or an enlargement of the scheduling order. The scheduling order is the discovery cutoff. Would you allow us to delay Colin Albert's deposition? And he said, no. They said they had strategic reasons. Emily, what could those strategic reasons be? Well, they don't want the witnesses talking to each other. They want to put the depositions in order so that they can follow up on... I imagine they would want to take Colin Albert's deposition before they took his parents' depositions so that they could follow up on it. They're allowed to order their depos the way that they want. I mean, in a perfect world, that might not always work out, but I wonder if he's bringing this point up specifically. So saying they told us they would not agree because they have strategic reasons. Sure.
Strategic reasons. And what it made me wonder is why they hadn't taken his deposition in the many, many months during which this case has been pending, and why they didn't take his deposition when he actually sat for it 2 weeks ago.
Because they didn't have the documents.
The answer to the latter question is they didn't have the documents.
Sorry, Judge. Sorry, Judge G. Sorry, Judge G.
In the many, many months during which this case has been pending, and why they didn't take his deposition when he actually sat for it 2 weeks ago.
Well, the answer to the latter question is they didn't have the documents, and they had said in their discussions with you that they wanted the documents before they took the deposition.
And they don't have the documents now, Judge. And so what I'm saying is, given the burden that this would place on Mr. Albert, and the fact that he's already been...
Excuse me for interrupting, but the burden is self-imposed. Because there was a subpoena, and as I've said enough.
Oh, shit. Judge G's out. Judge G's done. Judge G's like, you've punched yourself in the face and are like, stop hitting me. Stop punching yourself in the face then. The burden is self-imposed. I mean, whoop, there it is.
Excuse me for interrupting, but the burden is self-imposed because there was a subpoena. And as I've said a number of times, a subpoena has to mean something. And there was also some agreement between the attorneys. And the words and actions of an attorney need to mean something too.
Your Honor, let me just say a couple things in response. First of all, I am not aware of any agreement between attorneys. I've read that.
Here the fuck we go. I've read that email chain. We didn't agree. Here we go. The court's like, your word has to mean something. Subpoenas have to mean something. This court is over the gamesmanship. He made that clear last hearing. Oh boy.
But attorneys need to mean something too.
Your Honor, let me just say a couple things in response. First of all, I am not aware of any agreement between attorneys. I've read that email traffic. I was not the one negotiating this, but I've read that email traffic. And that deposition was canceled. And if they want to take a deposition of him on a different date, they can issue a subpoena for a different date. But it is my
If you're listening in the background, now's the time to come on back and look at Rosenberg's body language because damn. Here's the thing. Easy position for Mr. Maddie here to be in. Mr. Maddie's like, I'm not on those emails, but I read those emails and it was canceled. There's no agreement. Mr. Maddie's coming in hot, being like, no, if they want to take a deposition, subpoena him again. Good luck. And that's clearly not the position that the court is taking. The court made it clear last hearing that the court believes that this is still a valid subpoena. The judge is just like, oh, the fuckery that's afoot. Also, rescheduling depositions because you do not have the documents on the date of the deposition is so normal. This is nothing. The weirdness came afterwards. Then the other party's going to depose him. Like the weirdness happened after these emails. Oh boy.
A couple things in response. First of all, I am not aware of any agreement between attorneys. I've read that email traffic. I was not the one negotiating this, but I've read that email traffic. And that deposition was canceled. And if they want to take a deposition of him on a different date, they can issue a subpoena for a different date. But it is my understanding that there was no agreement. I also want to just say one thing in response to the idea that Mr. Albert has imposed a burden on himself. If he is told that his deposition is being canceled, and then he alerts everybody to the fact that he's decided to enlist in the United States Army to...
Who told him it was canceled, though? Who told him it was canceled? Are you going to try to throw your client under the bus? Who told him it was canceled? If y'all told him it was canceled, that's on y'all.
One thing in response to the idea that Mr. Albert has imposed a burden on himself. If he is told that his deposition is being canceled, and then he alerts everybody to the fact that he's decided to enlist in the United States Army to serve his country, and tells everybody that he's going to be available for a deposition in a compressed period of time, and one party decides not to take advantage of that, and then he enlists and subjects himself to basic training, and the idea is that he was supposed to organize his life choices as a non-party witness around when Miss Reed might ultimately decide to take his deposition. I don't think it's fair to suggest that he's imposed this burden on himself. He's undertaking...
Oh, you take issue with how the court framed that, do you? But Your Honor, it's not fair. It's not fair. It's not fair that y'all told him it was canceled when clearly the other side said, to be clear, we will reschedule after we have the documents. I mean, was there a cutoff for him enlisting? Because last I checked, he wasn't anywhere near like 35. He's also the plaintiff in another lawsuit. How was he going to deal with that? But Your Honor, it's not fair. Well, counsel, we're going to get back to Takesy v. Backsies. He was subpoenaed. Your Honor, our spring trap for opposing counsel didn't work. We said, well, we're going to take his deposition this day. You better show up. And I said when we covered that, well, What will the arguments be? If Reed's counsel shows up to that deposition, the argument's going to be they had an opportunity to depose him, even though it was scheduled on the day that the attorney who was going to depose him was unavailable and had told everybody they were unavailable. See, Your Honor, they were here. They could have deposed him. He's not coming back for another deposition. And then what's the argument if they don't show up? Well, Your Honor, they could have deposed him. They didn't show up to depose him. So that's on them. For them, it's a sword and a shield.
Burden to serve our country, made himself available for a deposition, and now all we're saying is, under these circumstances, wouldn't it make sense to conduct this particular deposition when the young man has completed his basic training, and after which we've resolved all these issues about documents?
Deposition wasn't canceled, Your Honor. You can read the emails yourself. I'm the one who wrote it. It said the deposition will be rescheduled when we resolve the pending dispute over the documents. Mr. Maddie points out we still don't have the documents. That's because they still haven't agreed to produce the documents, and we need to be back here with Your Honor for a second hearing to get what we believe is a significantly narrowed scope, which we proposed last week after Your Honor provided some feedback on the initial scope. Also, subpoena is not a request. Mr. Maddie said a request that he be deposed. It's not a request. It's a court order. The case law is clear. A subpoena is a court order. And obviously...
No, it's not a request. We're not requesting shit. We're demanding. Show up and be deposed. Okay, we'll reschedule. Give us the documents. No. Yes. No. A. Rose. Right. Right. Right.
We're not looking, as I've said, to impose an unfair burden. We recognized that the service didn't happen in time and immediately said, yeah, that's too tight. We will reschedule it. To now argue that by saying we will reschedule it, which is exactly what the email says, that we canceled the deposition and rendered the subpoena ineffective is, I think, absurd. And it flies in the face of the obligation that a party serving a subpoena has, as Your Honor pointed out, to work with the recipient in order to do it in an efficient way and not impose an undue burden.
Right. And what would have happened? What would have happened if they went ahead with the deposition without the documents and then said, well, we need another deposition. Now we get the documents. What would the argument be then? They've already subjected him to a deposition once, Your Honor. Why should they get a second bite at the apple? It's an undue burden to depose him once, to depose him twice. So why should we do it then? Right. So you can see where the other sides of these arguments are, each way that they go. And so if they did the deposition, they're in a more difficult arguing position to get the documents and do a second deposition. Like, we can see where all of this becomes a problem. And that's why we're just back and forth and back and forth and back and forth with what's the document discovery going to be and when's the deposition going to get done? And the question that the court asked was, talk to your client and tell us when he's available. And we've heard everything but that.
Which is exactly what the email says. That we canceled the deposition and rendered the subpoena ineffective is, I think, absurd. And it flies in the face of the obligation that a party serving a subpoena has, as Your Honor pointed out, to work with the recipient in order to do it in an efficient way and not impose an undue burden. I also haven't heard any of this until right now. We've been conferring. I heard that it's difficult, but the specifics of the steps that they've been trying to take, we haven't heard. I would have a couple questions. One, was Mr. Albert asked to identify this?
Hello, Mr. Rosenberg. We also have questions. We agree with you. We also have a couple of questions. In fact, the law nerds over here, we have lots and lots and lots of questions. We had lots of questions last week. We have lots of questions this week. We have lots and lots and lots of questions.
Specifics of the steps that they've been trying to take, we haven't heard. I would have a couple questions. One, was Mr. Albert asked to identify this proceeding and the subpoena that he had received when he enlisted in the military? If he was, does that impact his ability to come back to Massachusetts to appear pursuant to the subpoena that was issued in this case?
I mean, the question we've all been asking since last week, isn't it? You continue to ask the questions that we have all had since last week, because we were all just like, don't you have to say something? Because he's not just a third-party witness. And then I went back and forth last week, and I was like, well, if he's a third-party witness, I can see where that might be squishy. And then chat was like, girl, don't forget, he's suing Karen Reed. And I was like, oh, yeah. Correct, chat. That all has to be disclosed. Did it get disclosed? Question number 1.
If he was, does that impact his ability to come back to Massachusetts to appear pursuant to the subpoena that was issued in this case? At the end of the day, everyone here, I think, respects a decision to serve our country. But the timing of this is extremely relevant.
What are the other questions?
We served the deposition, the subpoena. We had the back and forth where we said we would reschedule. We waited 3 weeks for a response on the documents. We got an email that said, in effect, he's available for the next 13 days and then he's gone. That's not appropriate, and that's not in compliance with a subpoena that's issued by counsel through this court. And if there's something we need to do in order to make it more possible, I'm more than willing to hear what we can do to help do that, but there's been no proposals, just he can't do that. And to address briefly this idea of extending the scheduling order, as your honor is aware, we've been working over the course of many months now with the understanding from your honor that that is a hard deadline and we need to do everything we can to get everything done in that deadline. And we've made tons of decisions in reliance on that, and you've effectively kept us to that. We've got depositions, many this week that we're taking. Plaintiffs have taken a number. Things are moving forward. It'd be completely unfair for us to now have the deposition that we noticed early on in the schedule be put way back, in fact, after the deadline that we've all been operating under.
Your Honor, I don't understand any prejudice to Ms. Reed or her counsel.
That's not the standard. Prejudice is not the standard. Lyndon said a smart move to appeal to the court's sense of efficiency. Totally agree. But it's not about the burden. It's about the fact that he had this. And Anarchy, I see your super chat. We talked about it last week. We talked about that at the last hearing. So we have thoroughly discussed that it should have been noted. What we do not know is if it was or not to any certainty. But we do know that it should have been noted. So yes, we did that last week. And for all of you not reading chat actively, fair, that Colin Albert should have disclosed this when he enlisted. And we talked about that last week, that this should have and must be disclosed, and whether or not it was, which is why counsel is saying, right.
For taking this deposition 3 weeks after the August 17th deadline, I'm not understanding what the prejudice might be. I do understand and respect the need for court-ordered deadlines. Here,
I don't know what their strategy is. I don't know either.
That being said,
so their
whatever
argument
their
is what's the
strategy
harm?
was, apparently meant that they weren't going to take his deposition in the first year in which this case was pending, and then decided.
To be fair, for the first year that this was pending, they were stayed. So they couldn't take a deposition for the first year it was pending. Since the stay, they noticed the deposition and set it for April. And then they didn't have the document discovery. And now we're here.
That they would take it, and then when there was a dispute about documents, our position is they canceled it. Our position is that there is not a valid subpoena to be enforced right now. However, given the importance of working collaboratively with counsel, we are going to continue to do that. And if the court tells us that we need to find a way to pull Colin Albert out of basic training, we will go ahead and see what that process is.
Okay, good.
And pursue it. But I don't think that's fair to him. I really don't.
Ah.
And I don't think
Pretty if you please.
Attorney Rosenberg thinks that's fair to him.
It's a bold strategy, counsel. After the email back and forth, and after you're like, I've read this email chain and it clearly says canceled, when it clearly says we agree to reschedule until the document discovery is done, to then turn around and be like, and I don't even think counsel thinks it's fair. What does it matter? And B, not a his problem. Your client was subpoenaed. And now he needs to show up.
When we could take this deposition just a few weeks after one witness, then he will have finished basic combat training. He will be on leave. You won't need to go through this process, which I'm just now learning about trying to persuade the United States Army that they should release a witness for a civil proceeding in Massachusetts when they don't even let him have his phone.
Yeah, well.
However, if that's the course of action that the court wants us to take, we will work with Attorney Rosenberg to try to facilitate that. I just think
Maybe don't tell your client that the deposition's canceled and it's all going to be fine then.
it's highly unfair to this young man.
Pretty V, please, Your Honor, it's unfair.
To be clear, I do think I understand the burden it imposes, but as Your Honor said, it's a self-imposed burden that he knew he had the subpoena. He decided to enlist when he decided to enlist, and that resulted in him being unavailable less than 2 weeks after he could give the other side notice. So this is not someone who was already enlisted, who we tried to serve a subpoena or say served a subpoena when someone was back on leave, and then they ended up back under the control of the military. That's not what happened here. The timing is set out very clearly in the communications that are part of the record. And I think not only is it fair under the circumstances, I think it's required, and I would ask the court to order Mr. Albert's counsel to present him. And I represent to you that we will work with them and do what we need to do to assist that.
Right.
Well, first of all, he was available for a deposition.
Here we go. But Your Honor, it's not fair. But Your Honor, it's burdensome. But Your Honor, it's not fair. He was subpoenaed.
Assist that.
Well, first of all, he was available for a deposition. He was. He sat for a deposition in this case. And secondly, Judge,
with no document.
in all deference, if you order us to make efforts to arrange his appearance at a deposition, we will do that. But we do not have authority to produce him on our own. The United States military does.
I think it would be a great idea if you found out more.
We'll continue to work on that. I was hoping they would take.
Your Honor!
Bruh.
Let's not have anybody find out more. Make the order and let them figure it out. Little bit of, Your Honor! Little bit of urgency. Little bit of urgency. Remember you asked them to ask their client when he'd be available and they gave you a bunch of, we're doing some research? Make the order and then see what happens. Order it. You'll find out real quick. You should find out more. No!
Order us to make efforts to arrange his appearance at a deposition, we will do that. But we do not have authority to produce him on our own. The United States military does.
I think it would be a great idea if you found out more.
We'll continue to work on that. I was hoping they would take my calls. They didn't. But we will continue to work to find out more about how that process might.
You know what might help, Your Honor? If there's an order with some urgency. But if there's not an order, we're going to keep doing this.
Play out. I think I'm confident that the initial step would be reaching the staff judge advocate and informing them person to person of the status of the situation. I've left that information in my messages, but I haven't been able to reach anybody, and I will continue to do that if that's the court's recommendation.
You might not want to use the words, the other side canceled the deposition. Maybe couch it in terms that it's disputed.
It is disputed, and that's our position. Thank you, Judge.
Hey, Your Honor, how about you make some findings?
Thank you.
Your Honor, can I briefly just update you on that other motion I was talking about? It was.
Okay, on to other motions. Karen Reed's side is asking the court to grant their motion to compel Colin Albert's disclosure of documents and appearance at deposition. Last week, the court made clear that the court thinks that there is a validly issued and still binding subpoena. Otherwise, we wouldn't still be doing this. The court seemed to reiterate that today and said, you should couch this that it's disputed because the court, I don't think, is persuaded that the deposition was counseled, and the court has been proceeding as if this is a validly issued and still binding subpoena that needs to be adhered with, and asked Colin Albert's attorney last hearing, when are you producing your client? And today we've gotten just a lot of a circle on, but we can't. At some point, the court's going to have to mount up and ride too and say, I am compelling Colin Albert's appearance at a deposition by this date, and see if the deadline hastens action a little bit. But the court defaulted back at the end of that to, well, we're going to need some more information. And this is why this discovery deadline is going to get punted. And I imagine we will probably see this deposition scheduled in the fall, based on everything else we've seen. That's what I think is going to end up happening. I think it's going to be a long, frustrating road to get there. I would love to be surprised by the court's orders, but I don't think we are. Carlo said, Emily, isn't it in the court's power to make them cooperate or hold them in contempt or something? That's what they're here for. This process is one party saying to the court, can you please make them do this? And the court has not ordered yet. The court is still having discussions about it. They're still negotiating. However, this is going about as well as negotiating with a pissed off toddler in a Target, because it's just circular and feet stomping but it's unfair, Your Honor, but it's unfair. Sometimes you just have to pick your kid up and be like, and we're out. I'm calling it. And at some point, the court has to call it and say, I'm ordering you to do this, this, and that. That's what the motion to compel is. I'm ordering you to produce your client for subpoena or for deposition by this date and to turn over documents in these categories. That's what they're doing. But the judge keeps putting it over. So that's where we're at. And the judge has continued to do this throughout this case and purport to put their foot down and then give everybody more time anyway. So, okay.
That you asked at the
This is regarding, we now have Rosenberg, who is Karen Reed's attorney, talking about other motions. We heard about this at the end of the last hearing, that there would be further motions to compel coming.
Thank you.
I'm saving some of your questions. You guys have great questions.
Your Honor, can I briefly just update you on that other motion I was talking about? It wasn't that. You asked at the end of the last hearing what other motions were coming to you. There's one that relates to Mr. Matt. Well, I think Mr. Maddie's representing them, but the other individuals.
He's not jumping up.
Yeah, I know. I don't want to. Well, he's representing some of them in the defamation case.
Yeah, I don't want
to hesitate.
I don't want to take too many liberties with the court's
indulgence.
indulgence.
I was trying to be careful, but we've got deposition notices and a motion to compel for Brian Higgins. Not Brian Higgins. Brian Albert, Nicole Albert, Jennifer McCabe, Matt McCabe, that's coming to you very shortly. We discussed that earlier. Separately, we had a deposition scheduled of Lieutenant Brian Tully of the Mass State Police. We served Lieutenant Tully with a subpoena May 5th, and it sought documents June 1st and June 11th, so we did a better job with the service. His counsel asked to reschedule for July 8th. We rescheduled. And then the day after our hearing last week here, we got a motion to quash saying asking the court to say he doesn't have to show up at all, doesn't have to produce any documents.
Oh,
Came out of the
boy.
blue. They didn't confer with us. We don't know why there would be a change when.
So much information just happened, but what? Look at the court's face. Your Honor, part of this is your fault. I hate to be critical of the court, but if you keep extending the deadlines and not holding anybody's feet to it, this is where we end up. And the court's like, fuck. Look at the court's face. Fuck. Uh-huh. What did Reed's attorney just say? We have motions to compel depositions of Brian Albert, Nicole Albert, Jen McCabe, and Matt McCabe. And we just got a motion to quash the subpoena from Tully. And the judge is like, shit. Right. Saren said, Emily, remember that thing you said last week about strict teachers who get all their homework submitted on time? Exactly. Exactly. He's already given too much wiggle room, and now everybody's wiggling. They're like, full wiggle it just a little bit. Not the wobble, because I've seen what's happening with the way people are wobble dancing. I don't even understand. So we're going back even further. We're going back further than wobble. Wiggle it just a little. Now everybody's just wiggling. Right. You know what I haven't seen in the federal case? All of this. This is not all happening in the federal case. Yep, Your Honor. Welp, that's me. I bet you're wondering how I got here. With every third-party witness that needs to be deposed, trying to reschedule their depositions.
We accommodated the date so that we served an opposition to that motion the same day we got it, which was last Thursday. And we urged them to please file it with this court as soon as we can. I don't believe that's happened based on the docket, but I just wanted to give you a heads up that that is on its way.
So no 9B, 9C conference.
Parties should talk about this.
Why is he saying they didn't confer with us? Because there's an obligation to confer. But they're trying to, it sounds like also Tully. So now we have fights over the depositions of Colin Albert, Brian Albert, Nicole Albert, Matt McCabe, Jen McCabe, and Brian Tully. And Trooper Proctor, though we don't know if they've rescheduled it, but maybe.
But I just wanted to give you a heads up that that is on its way.
The four parties should talk about this. A motion ready to be filed?
Yeah, I believe the opposition is due today.
It's my understanding that we'll be serving our opposition, or that those individuals to whom the motion is directed will be serving their opposition today, I believe.
And we'll aim to file it tomorrow.
I do represent a number of them in the defamation case, Your Honor. It's the same situation as we have.
Right, which is why all of this like pro-hawking into this or that is confusing.
With Mr. Albert here, I'm not admitted to represent them as witnesses here.
You're probably going to be here on their behalf next time.
Well, if Mr. Tuxbury's still on vacation, I probably will be, yeah. With your permission.
How great for Mr. Tuxbury. Have a nice vacay.
Of course.
When would you like to do that?
Shit.
Before we jump to that, the plaintiffs have two forthcoming motions.
Wait. Buck, hold on a second. Court, when would you like to do that? Buck's like, wait. And here's where it's such a mess. because he's not pro hocked into this case. He is pro hocked into the other case. They're not going to cross over, even though it's in front of the same judge. And now the plaintiff is chiming in. This is the attorney for the O'Keefes, Mr. Buck. Hello, Mr. Buck. But the court wants to know when we're having a hearing on the other motions to compel.
Contrary to public belief, I have other cases that have depositions too. Personally, I don't, just for the record, to be clear, I don't want to convince the U.S. Army of anything. But the plaintiffs have forthcoming motions to compel Aidan Kearney, as well as further answers to interrogatories from Miss Reed,
which has been ongoing.
I believe the opposition was just served the end of last week. I have been out of the office Friday and today, so I believe that both will be filed either tomorrow or Wednesday.
When would you like to do those?
Did you hear the weighty breath of the court? When are we going to do that? So, what is now on the line? A motion to compel responses from Aidan Kearney, a motion to compel further responses from Karen Reed, which has been ongoing, motions to compel everyone else who we just listed. It seems like everyone but Higgins at this point. Okay.
I assume we're going to have 4 now. I think we're going to have those 2. We're going to have ours as soon as Lieutenant Tully's counsel files his 9A package, and then our motion. So I'd say as soon as we can, because...
Or I was going to suggest right after the 4th of July holiday, possibly. We have a robust deposition calendar, as your Honor's aware.
That's good.
I don't know if the court schedule, we could do July 2nd to get it, because Lieutenant Tully's deposition is supposed to be the 8th. We've got that set aside. Everyone has that set aside, I think.
I believe we're scheduled for a 30v6 on the 2nd.
I think that's the one that he just emailed and said that they asked you.
We were double booked that day.
Okay.
So there's a 30v6 of C.F. McCarthy's.
How about the 6th? It's the Monday after.
And now, lawyers fight with calendaring. Every single time, because there is so much going on. I don't blame them for the calendaring issues. There is so much happening that trying to find a time to get back into court is challenging. I agree with you. I like Mr. Buck quite a bit. Every time Mr. Buck is on the record, he is just pretty upfront. There's no blustery grandstanding. He's always a little bit funny. He always kind of throws everybody else's nonsense under the bus. I like Mr. Buck a lot. I find him much easier to listen to. He's just like, yeah, I get it. We're double booked. We've got the thing with C.F. McCarthy's. And it's like, okay, sure.
I don't think we have a depot.
I'm not aware of anything currently scheduled for the 6th.
This is my only case, so don't worry about it.
Just like all of us, Your Honor.
Not true that it's the court's only case. But now the court's trying to be funny? Your Honor. Okay.
They look like Kelsey.
It looks like we just have one thing on the afternoon.
Say it again.
You only have one matter on calendar, July 6th? Really? That doesn't seem like a lot. How do you only have one matter on calendar? Maybe this is the problem. The problem is that I'm viewing this through the lens of Los Angeles. Maybe the court's calendar really isn't busy enough. And he's just like, I got time. Why don't you guys come back twice a week and just keep me in the loop? Maybe the court needs more on their calendar. Busy schedules tend to get things done faster. Maybe that's the issue.
We don't have a trial that day.
Either that or he just likes Mr. Buck and he's like, hey, come on back, buddy. I appreciate that the clerk reached over and muted the microphone so that they could talk about the court schedule. I appreciate that. Wise. I also like the clerk's dress.
So.
Or judicial
we say
assistant.
2 o'clock.
I don't know which is the correct parlance, but I appreciate it.
On the 6th.
July 6th.
So why don't we say 2 o'clock on the 6th?
Would that be for the first motion Attorney Rosenberg described as well?
Whatever you got
Altogether.
out there, let's get it
Yeah.
all in here. And
The court's like, whatever you got, just bring it all in. Just bring it all in.
Okay, all right.
Yeah, we'll file it as soon as.
What I'd like to do, Judge, if you don't mind, if we could tentatively set that as the date, and then I could consult with co-counsel, just make sure that works for them, and if for some reason there's an issue, I could confer with Attorney Rosenberg and everybody else. Would that be all right?
Have we seen that sidebar for a second?
sure. Come on up.
Okay, so this matter is continued to July
Sidebar.
6, 2026 at 2 p.m. for the motion hearing.
And end of sidebar. All right. The matter is being further continued to July 6th at 2 p.m. That does not negate the additional hearing that is coming up in this case. This is in addition to the next hearing because this case has a hearing. Hold on, there were too many cases. This case has another status conference with all of the attorneys set for June 26th at 9:45 a.m. So they still have a June 26th, 9:45 a.m. That is supposed to be in the morning before they have other depots with all the attorneys for a status conference. And then this is a continuance for further motions to compel. So even though a lot happened in court today, they have not moved the ball significantly further, but a lot did happen in court today. So let's see what else happens before we talk about what actually got accomplished in court today, because I think they did accomplish a few things, but not maybe as much as one would hope.
Still have our status on Friday at 9:45.
At your Honor's direction, the World Cup fan inside of me put that aside and worked through the weekend to update the court on the pending motion to compel documents for Ms. Reed. Would you like to hear that?
Go ahead.
Wait. They just called the end of the calendar. Buck, they called the judge is standing with his files. But wait, there's more. The clerk has gone like off the record. They have called the further status conference and Buck's like, wait, one more thing, Your Honor, but one more thing. But wait, there's more. Okay. I don't think this is necessarily Buck's fault because at the beginning of the hearing, he said there was a thing, I think. So I guess we're not done with the hearing. All right.
Status on Friday at 9:45.
At your Honor's direction, the World Cup fan inside of me put that aside and worked through the weekend to update the court on the pending motion to compel documents for Ms. Reed. Would you like to hear that?
Go ahead.
Okay.
So for our conversation last week, there was a link sent to me.
This has been ongoing. Let's do a quick road so far on what Buck's now talking about because we've completely switched topics. So we have finished the hearing on the motion to compel documents and deposition of Colin Albert. The attorneys have updated the court on the status of future motions to compel, and there's a bunch of them. We'll get back to it at the end of the hearing. And as the court was standing up and they set new dates, Attorney Buck was like, wait, one more thing. The court asked me to update you on the status of the motion to compel document discovery with regard to Karen Reed. We went over these motions. They had not had a hearing on this motion yet, but we went over the motion where they said we sought further discovery. This is the motion where Rosenberg said, hey, Diller. Buck was not the one on, he was on the email chain, but not the one emailing. Hey, Diller, you could have just asked me. Remember those motions where Attorney Rosenberg said, why did you wait until a month past the discovery cutoff when you hadn't heard from us to bring it up? This is the one where Rosenberg was like, I wasn't on the emails. So you're reaching out to lawyers that are not the lawyers handling discovery in this case. I wasn't on the email thread. I didn't get notification of it. So we didn't know. Why didn't you just reach out to us before you filed the motion to compel? And we are working to get you the discovery. So just like, hey guys, hadn't heard from you on this motion to compel. That's weird. Can you get us the documents? So Rosenberg was going back and forth with Diller saying, we'll just turn it over. And then the last time this came up, Rosenberg said they're asking to go forward with the motion to compel because Rosenberg asked them to take it off calendar. They're asking to go forward with the motion to compel, but we're already turning over the document discovery. But that had happened the morning they were just in court. And at that point, Buck was like, they said that they sent it, but I haven't had a chance to confirm. Like, I can neither confirm nor deny that what they sent us is what we are looking for. Like, it might not be what we're seeking. So the court said, okay, go ahead and update me. And Buck said, we will review the discovery and update you. So when Buck said, I worked through the weekend to review it, Buck is letting the court know, I went through what they turned over to see if it was responsive. So we no longer need the motion to compel. So they are trying to, it sounds like, work through whether or not the motion to compel really needs a hearing or whether the things that were turned over are sufficient. So that's where we're at now with the email of the, I wasn't on the chain. Why didn't you just ask? Why do we need a motion to compel? Can't we try to work it out together? And before we need to bring it to the court. And Diller was like, no. And Buck's just like, I mean, I was doing discovery with the TV on in the background. So can I at least tell you what I did? I don't want to waste the entire weekend. Like, you got the other dude who's like, I was trying to call the military base on a federal holiday and like over the weekend and no one responded to my calls. And Buck's like, wait, Your Honor, I didn't go out with the Tartan Army this weekend. I'm going to tell you about the work that I did. Good for you, Buck. Let's see what the update is.
Well, Attorney Fell and I were conducting a deposition prior to the hearing here on Wednesday, the 17th. Over the weekend, I was able to access that link and confirm that there were responsive documents included. And the plaintiffs have some concerns to date. We have submitted 53 requests for documents to Ms. Reed. 34 of those were met with objections for attorney-client privilege and work product. I do not have any privilege logs to date, nor do I have what I believe to be compliance with Superior Court Rule 30A that states the documents that are being withheld due to that specific objection. That being said, Ms. Reed is scheduled to offer deposition testimony on Wednesday of this week, less than 48 hours from now. The first testimony she's given to date. And my clients are at an extreme distance.
Yeah, you can't, and Reed's attorneys have argued this too. Reed's attorneys have been arguing in others, hey, people are objecting to attorney-client privilege and there's no privilege log. This is now the flip side of the same problem. So the problem that Reed's attorneys are complaining about as to others is now also what Reed's attorneys have not turned over, which is the privilege log. So Reed's depo is supposed to be on Wednesday, and they're like, so we've gotten a lot of objections, but no log. So everybody's just like, I know you are, but what am I? And they're all correct. I know you are, but what am I? I know you are, but what am I? I know you are, but what am I? And for those of you asking for a privilege log, it's big, it's heavy, it's wood. No, I'm teasing. When you object to work product or attorney-client privilege, you have to cite what the thing is. So if it's an email thread that might be responsive, it would be email thread on this date between lawyers privileged. And so you have to say what the thing is that exists that you're not turning over, because you're not objecting and saying that doesn't exist, or you're not objecting and saying that's not relevant. The objection is, hey, we have a document or an email or whatever it is. We have a thing that might be responsive, but we're saying the responsive thing cannot be turned over to you because it's protected. And you have to list what the thing is and then say it's protected. And so the privilege log is something both sides have been arguing about, because you can't have further argument to the court about why that should be turned over unless you know what the thing is that's responsive, be it documents, emails, whatever. And so that's what they are asking for. All right, let's continue on.
Disadvantage, because I anticipate forthcoming motion practice as to those objections, but without knowing what's withheld, I can't pursue the additional motion practice to put in front of this court to determine whether or not that privilege upholds.
This issue, Mr. Buck and I discussed, right, for the first time at the beginning of the last hearing last week on Thursday. As I told Mr. Buck, we agree we're going to get them the information that's required by Rule 30A. We're working on it right now. We're already working on it when Mr. Buck asked me first on Thursday, and we will get it to them. This is the first I'm hearing of an issue tied to the upcoming deposition. I will talk to the people that are doing it right now and try to get that to.
Rosenberg. On the other side of this, if the documents aren't turned over, why would you think that it wouldn't be an issue for deposition? It's same. Of course it's going to be an issue. So now everybody's kind of, the arguments have just kind of switched sides on this. Well, it's the first we're hearing it's an issue for deposition. Okay.
Them before that deposition, but they have, obviously they'll decide how to handle that at their deposition.
Maybe remind them that if you're going to make such an objection, you're supposed to provide the privilege log, not something you work on after you make the objection.
Right.
Well, we identified the objection, and then once we've withheld the documents in the production that just completed.
The court's right. When you make the objection and say what's being withheld. So, right.
We are providing the information, but
I know
it's taken.
This is not the collective view, because you get someone else you got to consult with, but they obviously had the documents in front of them in order for them to make the objection, right? So the next logical step would have been, let's give them a privilege log.
Well, not necessarily in front of them when they made the objection, because the objection is made in the written responses. You're not looking at the documents at the same time. But I understand, Your Honor. We're not fighting that.
We did have a conversation about it, but to
Rosenberg, you have raised the exact same objection. Come on, everybody. Your Honor, they didn't give us a privilege log. Well, Your Honor, they also did not give us a privilege log. And I'm not giving you my log until I get your log. Dawn, everybody. Dawn. Bring your logs and exchange them in Weehawken. What are we doing?
To Your Honor's point, the initial responses to my first request were served on me in October. I don't have a privilege log for that request either.
Attorney Rosenberg, it's similar to the last discussion on the motion to compel. You collectively suggested the issue was moot because you had filed a written response, but you hadn't produced the documents. I know you've taken care of it, but all that just engenders delay.
I agree, but I would say the reason that those keep coming before you is, like right now, we haven't had a conversation yet under Rule 9C about the timing of when we're going to give you.
The court's like, this is just causing more delay. And Rosenberg's like, well, Your Honor, they didn't ask us for the privilege log. Dude, you have to turn it over. They shouldn't have to ask for the privilege log. If you're objecting to privilege, you have to turn it over at the same time. It's been 84 years. All sides are objecting to the same issues vis-a-vis one another. Okay.
Give them the privilege log. It was raised for the first time at the beginning of last Thursday's hearing, and my response was, you're right, we're working on it, we're going to get it to you. This is supposed to happen, frankly, outside of the court. This is supposed to say, we need it by Tuesday because her deposition is out on Wednesday, and let me respond.
But I think what Attorney Buck is saying is we should have got it a long time ago.
And I'm by no means here claiming nefarious action or anything of the sort. I'm stating facts because Superior Court Rule 30A states that where a privilege log is required, the log shall be served with the supplemental response unless the requesting party waives entitlement to the log or agrees to a later date for service.
I'm not suggesting nefarious actions by anyone. I'm just suggesting actions that result in delays. More need to come in front of me and talk about this stuff.
I understand that, Your Honor. I'm just saying, I think we didn't need to come before you to talk about it, frankly. And the supplemental response is the supplemental written response in Rule 30A, which comes after the documents are produced. So I really don't think this is something we need to quibble with before Your Honor. We will get it to them as quick.
The problem is, I understand you're saying we don't need to quibble with it in front of the court. But the other side is saying when you make those objections, you have to turn it over at the same time, and you haven't done that. So turn it over at the time you're making the objections. That's what the rule requires. And that's what the other side is saying is, look, here's the context that we're in. Just to back this up a little bit. The context that we're in is that, as the court said, the plaintiffs' O'Keefe parties brought a motion to compel. The Reed party said, but it's moot. We've already turned it over. And the plaintiffs are saying it isn't moot, though, because you've objected to privilege, but not provided any privilege log. So it's not moot because it's not done. You've done some of it, but you haven't done all of it. We got to get to 100% done. Like, we can't 75% it and be like, it's good. We don't need this motion to compel anymore because it's not moot. And that's what the court's saying. The court is saying this isn't moot because even though you turned off the documents or turned over the documents, you didn't turn over the privilege log, and that needs to be done too. So now Rosenberg is on the other side being like, well, they didn't bring it up to us, even though it's required by the rule. And now we've got Rosenberg arguing the same way we just saw the other side arguing. Because they haven't turned their stuff over yet either. The Annie said, what is a privilege log? We talked about it briefly, but they're objecting to turning things over. Hey, we have thing A. We're not turning over thing A because of privilege. There's a variety of privileges. We're not turning it over because of a privilege, attorney-client privilege, work product privilege, whatever. But you have to say what the thing is. You have to define it when you're listing your objections in response to questions. So let's think of this in like a game of Go Fish. Imagine in a game of Go Fish where you say, hey, do you have A? And the response is, I have A, but there's a reason I don't have to give it to you. You have to disclose that you have A and then disclose why you're not giving it to them. You can't just say, go fish. You have to disclose that it exists and why you're not turning it over. So that's what the privilege log is. It's describing the thing that's not being turned over and why.
Quickly as we can, and if we can do it before Wednesday's deposition, we will do that.
Probably not going to complete the deposition in a day anyways, right?
I don't anticipate that the likelihood of that is very high.
Certainly with other parties too.
Yeah, I just wanted to confirm that you had requested that I review the link, and I've done that. And as we sit here, my preliminary review shows that I received responsive documents to 3 of my 16 requests. So I anticipate further motion practice and at a later date. But you requested that I look at everything, and I did.
All right.
That's fair.
See everyone on.
Also, do you notice the difference with how Attorney Buck addresses this? Attorney Buck is not, pounding the table and making a protracted soliloquy about clickbait lawyering. Attorney Buck's like, hey, Your Honor, so we got responsive documents to 3 things. And we got objections to the other 16, and we didn't get a privilege log. But we got privilege objections. So we need that turned over. And we got a depo on Wednesday. And so we've got a problem that we need these responses to be done. The motion that we filed is not moot. We are still trying to work on it. But this is where we're at. And so, again, Rosenberg was the one who was shuffling, to the side on this one. Wiggling. Well, Your Honor, yes, we haven't turned over the privilege log yet, and hopefully we can get that done before the deposition on Wednesday. And we understand, but we still think it's moot because we turned over responsive documents even though we didn't do the privilege. Then it was Rosenberg's time to do the, just a jump to the left. And this is why we are not getting anywhere. Because they're still just like... Oh, my goodness.
On Zoom on Friday morning at 9:45.
Looking forward to it.
Not me, Your Honor, right?
We'll admit.
And the court's like, don't forget, everybody, I'll see you Friday morning for status. And then I expect you to all, I need to be there for Friday morning for status because I want to know. Shit, where will I be? Not here. I want to know if Karen Reed's deposition goes forward tomorrow or not. And I imagine it will be discussed on Friday's status conference. I'm going to save a few of your questions. We're going to try to wrap up this hearing. And the court's like, so you're all going to be there Friday? And Colin Albert's lawyer is like, I'm not part of that, right? I'm not part of that royal we.
Morning at 9:45.
Looking forward to it.
Not me, Your Honor, right?
We'll admit you if you want.
Not yet.
Thank you.
Thank you.
Thank you, Your Honor.
Thank you, everyone.
All right.
Oh my goodness. Well, WFXT TV, thank you for the footage of the hearing. That was fantastic. That was so helpful. I'm glad we had the hearing because there's a lot going on in this case. And this is just one of 4. For all of you who are like, Emily, civil's exhausting. I know everybody was like, can we get a break from all of the criminal stuff? Yes. However, covering civil cases at the outset reminds you why they settle and why they settle so much. So where are we at the end of the extended hearing on June 22nd, as we reviewed it on June 23rd? We have heard that Karen Reed is supposed to sit for her deposition on Wednesday, June 24th. And working from the end of the hearing backwards, there is a motion to compel Karen Reed that is still outstanding. Karen Reed's team has argued that that motion to compel is moot, and they have turned over responsive documents. Attorney Buck for the plaintiffs, who is so much easier to follow for plaintiffs' counsel, and I think would probably be better in front of a jury, but maybe it's just because Diller, after the first 2 hearings, has just rubbed me the wrong way with the clickbait soliloquy and the I'm never deleting this email nonsense. But Attorney Buck was like, look, I know they say it's moot. It's not moot. Yes, they've turned over some responsive documents. However, there were also documents that were withheld for various types of privilege. Those withheld documents have not yet been identified in a privilege log. We need to have that. Rosenberg's like, well, we haven't talked about that yet, but we know that we need to turn it over, and we're going to try to get it to them by Wednesday, but I don't know if we'll get it. And then the court's like, okay, well, this shouldn't be a problem for deposition, right? Because Karen Reed's deposition is going to be multiple days. And so the court was already kind of signaling that the court is not inclined to delay Karen Reed's deposition because there are multiple parties taking Karen Reed's deposition, and it will probably be a multi-day deposition because it's not just the plaintiffs. It's the plaintiffs and the 2 hospitality defendants, C.F. McCarthy's and the Waterfall. So there are multiple parties that will want to take Karen Reed's deposition in this. And to follow up on the question, Emily, what about the witness third parties that are suing Karen Reed in other litigation? No. Those parties are not a part of this deposition. These depositions are for the plaintiffs in this case and the defendants in this case. Does it mean they're not going to subpoena them in the other cases? No, they'll subpoena them in the other cases. But do they get to sit in and ask questions? No, not in this one. So it is plaintiffs' counsel, C.F. McCarthy's, and the Waterfall, and Karen Reed. That was regarding the outstanding plaintiff's motion to compel. We still have an ongoing motion to compel with Colin Albert, where the court ended up with subpoenas need to mean something, attorney's words need to mean something. I think the court has very clearly signaled that he does not think that the subpoenas expired because it was a canceled deposition. It seems to me pretty clear that the court is of the mind that that deposition was rescheduled, and the court signaled that a couple times in this, though has not made an official ruling because the court got through the round and round and round and round and round and round of the attorney arguments and then said, it sounds like we need more information about how to get Colin Albert here. Great. So they're going to follow up on that July 6th. And then Rosenberg's like, one other thing, Your Honor, for Miss Reed, we also got a motion to quash a subpoena for third-party witness Tully out of nowhere, and that's going to be filed on the docket. And Tully's deposition is scheduled for July 8th, and now they're trying to quash the subpoena for his deposition. So we're going to need to deal with that. And we're going to need to deal with the fact that we are bringing motions to compel not just Colin Albert, Brian Albert, Nicole Albert, Matt McCabe, and Jen McCabe. And that harkens back to the hearing a few weeks ago where counsel was like, at 10:20 this evening, I got an email from the same lawyer that's Colin Albert's lawyer saying, oh, by the way, these parties aren't available for their depositions, and all of these depositions need to be rescheduled to the very end of July. Great. So there is going to be seemingly fulsome and protracted motion practice on motions to compel all of these depositions. And at one point, the camera, and I'm so glad there was a camera in court for these hearings, because it is so much easier to just see how the attorneys are arguing, what they're saying in court, how the court is responding. And again, the way the court responds, sometimes this court is joking, and you can hear when the court is joking with the attorneys. Sometimes the court is not joking and is like, get it together, everybody. And sometimes the court is just looking at the desk going, we're never done. We're never going to be done. We're never going to be done. And this is the judge who also has the defamation case where Colin Albert and Jen McCabe et al. Are suing Karen Reed and Aidan Carney. Oh, and then we heard that there's also a motion to compel pending for Aidan Carney that hasn't been filed or might have been filed today. The civil litigation is not going to slow down anytime soon. And there will be more hearings for us to cover. So, where does that leave us? The court seemed to be of the mind, though has not made a ruling, that Colin Albert is going to have to sit for deposition, and the court does not want to extend that until the fall. And the court wants counsel to answer more questions. I'm surprised the court didn't say, okay, well, what might be helpful is if I just make a court order in addition to the subpoena, and you take that to the Army and say, hey, the court has ordered Colin Albert's appearance. So we need him back for a day. Go give it to the court. Or they need to try to arrange a subpoena on or a deposition on base, which is an option. I don't think any of the parties would want to do a Zoom or video deposition, remote deposition of Colin Albert. I think it's probably something they are less inclined to do. But could the Army allow that on base? Sure. Or could they find a conference room in the same town as the base and all go there? Yes. They don't have to bring Colin Albert to Massachusetts. All the lawyers could go to where Colin Albert is and say, we need him for a day. They say his day starts at 4:30 a.m. Great. I mean, I wouldn't want to be that lawyer doing the depo. But he's used to his day starting at 4:30 a.m. Great, let's start this depo at 6. They can go to where he is for a day and do his deposition. No one has suggested that yet, but it's possible. There are still lingering questions because Colin Albert's lawyers have said like 4 different things, and it's difficult to pinpoint the veracity of what they're saying. Is Colin Albert in this 3-week school before he's in basic? Is he already in basic training? Is he available in the fall? Is he not available in the fall? Like, the information has been inconsistent and frustrating. And I know there is going to be a lot more conversation regarding Colin Albert online. I am waiting until I have seen things that are either confirmed by multiple sources that I trust or in court filings. So I know that sometimes there's like, but wait, Emily, there's more. Until I am comfortable with the, but wait, there's more, I'm not going to bring it to y'all just yet. I'm waiting to see. But I still have questions. And those questions so far haven't been answered. And I'm frustrated with the court. I'm frustrated with the court for not putting his foot down more. I'm frustrated with the court for saying, okay, well, go get more information. We'll all be back here next week again. And then the court's like, this is just dragging on. Shocking. Shocking, Your Honor. But if they're being pulled into court every week, I mean, maybe that will help them get things done. But if the lawyers are saying one thing's an email and then they get into court and change their story, no wonder nothing's working. And no wonder nothing's moving faster. But I do think here, granting the motion to compel would move particularly this along. Because then it's not a, hey, we have to make him appear on a subpoena by this date that's in dispute. It's, hey, the court has ordered him appear by this date. And I think that would put a little bit of urgency into everyone for getting those answers. And this is all, undergirded by the fact that Colin Albert is a plaintiff in the defamation case. And counsel said today, which I had forgotten, that counsel said today that he's also a victim in the Turtle Boy criminal case. So it raises the question again. How did Colin Albert's lawyers think this was going to go when he's a victim witness in a criminal case, a plaintiff in a civil case, and a necessary witness in a third case? How'd y'all think this was going to go? And was all of that disclosed? Because that's not just I might be subpoenaed as a witness in this case. Being a named victim in a case that's a criminal prosecution and a named plaintiff in a case go well beyond that. And if his base, recruiter, and chain of command weren't aware of that, I imagine, based on what all of the law nerds have said who are in the military, and thank you, all of you, who have shared your experiences, and to the number of recruiters that have chimed in either themselves or through their spouses, that's something that has to be disclosed, as we talked about last week. And if that was disclosed, wouldn't that delay basic training? So logic, I have questions. I have questions because they do have to disclose that. And if that's not disclosed, based on what all of the law nerds have shared, that can cause problems. I'm not going to get into that further because that's not my purview. I'm going to wait and see how it plays out. And law nerds, as always, I encourage you to stay with, I have questions. I have a lot of questions. And we'll see if they get answered. But God, if there was any multiverse that needed cameras in the courtroom, I think this is it. And for all of you that are like, good Lord, with the civil law, I know. You've got questions. I've got questions. We've got questions. Let's get to answering your questions because there are a lot of them today. And I think the law nerds are just the smartest ever. And so we should answer those questions. Y'all ready? Let's go. Questions. I mean, we'll see if we can answer the questions. I continue to have questions. I continue to have so many questions. Let's see. Rando from Iowa makes an excellent point. The Army cares because otherwise anyone could commit a crime and go hide in the military. Right. You do not want it to become a rehomed situation. 100%. And if that was not disclosed, well, I imagine that will cause problems. Riley Bear said, EDB, why does the unicorn look so angry? Because we have yet another hearing. Another hearing, and another hearing, and another hearing, and another hearing. Just the fuckery of the... Okay, well, go find out. You said that to them last week. Leonard said, EDB, is it a common occurrence for everyone to not want to be deposed? I did not do a ton of civil law. But in the time that I worked with civil judges, this fight was happening in almost every single case. Because the point is to narrow the scope. narrow the scope of the documents, narrow the scope of the depositions. It is to narrow the scope. Civil law can be very much won or lost in the lawyering differently than in other areas of law. And the chessboard strategy in civil is very different than the way criminal cases go forward. And in criminal cases, it is a rarer circumstance where things are not turned over. And they should be. And if they're not turned over, there can be massive problems. And we've covered that in a number of criminal cases, including the Alec Baldwin Rust case. There are really severe and should be severe consequences for not turning things over. In criminal, more often, it should be turn over more, argue that it doesn't come in at trial if it's not relevant, and then that's how it proceeds. But in civil, there is much strategy to play out, including the strategy of where to file a case, what counts to file, if you file a counterclaim, if you don't file a counterclaim. It is all strategy. And a lot of that strategy is gamesmanship. And if you get a ruling that goes your way, it can change your case. If you get a ruling that doesn't, it won't. So it's very, very common to at least try to narrow the scope of the document discovery. Even if like, we'll sit for this, and then we'll fight over the documents that are getting turned over that you can question them about and stuff. So yeah, civil is this. And it is why a lot of people choose not to. And it's easy, and we see this online, and we don't cover it all the time, but we see people online saying, well, why doesn't somebody sue them? We can talk about this more in context in the Bricks and Minifigs Lego case, right? Well, why don't you just sue us then? Was the corporate response. Sue me. Go ahead. Because it's expensive, it's time consuming, it's stressful. So it's easy for a party that has more bandwidth and more resources to say, if you got a problem with it, sue me then. Because you can end up in litigation like this for years and years and years and years. And that's why you see a lot of people opting out, even if they could sue. Because, well, now we're going to get to juice v. squeeze. Because part of the calculus there is it worth it? And at the end of the day, what are you going to get? And will the thing that you get at the end of the day right the wrong that has been done? Or will the thing that you get at the end of the day be the teeniest sliver of what has been lost in going through the process to litigate? It's tough. And so that is, hi, Fred. So that is part of why there's a lot of people that are like, so sue me then, knowing that people don't want to necessarily engage. Because it's hard. But yeah, is it worth the squeeze? For sure. Oh, litigation. So I find it frustrating too, because all of it is the parsing, where criminal is more like, there are rules, follow them. There are limits on the fuckery. Also, I didn't want my job to be constantly like, per my last email, you suck. And then fighting over commas. It was just like, here, we'll turn all of this over. That's not relevant. That shouldn't come in. That shouldn't go to trial. But it was much easier for me to be like, nah, turn it over. Like, we're redacting out those addresses so nobody gets killed, but like, turn all that over. So much easier. And generally more collegial on the whole than civil. So, Camoto said, why did they sue if they don't want to be deposed? Right. They're going to have to be deposed, but it's a matter of when. So this is all, when is it going to be deposed? So the timing is also strategy. Yeah. I don't know. Because they knew it was coming. And I think that's where part of this is so frustrating, is because a lot of it feels just performative. And I'm sure the lawyers don't see it that way, but there is a lot of fighting happening in the wrongful death case, knowing that we're going to eventually end up in the same place in the other defamation case. Like, we're going to all end up there anyway. And that's part of what's so frustrating to me. So, what are we doing? Fred's fretting. We'll see. Yep. JCM said somehow criminal court seems more civil than civil court. 100%. There are also much stronger rules because you are dealing with different rights. And so the rules in criminal don't allow for as much fuckery. And then also the punishments for fuckery are much stronger. And at the end of the day, in civil, there is a bit more gamesmanship. In criminal, the goal should be, though we don't always see that, but the goal should be to try to get to the truth of what happened. That should be the goal in criminal. And sometimes that truth is that person didn't do the thing. And sometimes that truth is that person did do the thing. And sometimes that truth is, yeah, it seems like that person did the thing, but I don't think we can prove it. So that's not going forward. But the goal should be getting to the truth, not winning. And when criminal lawyers act like winning is the goal, shit goes off the rails. And that winning should never be the goal. If you have a strong case, a jury will understand. Period. If you don't have a strong case, you shouldn't have filed it. I mean, easy for me to say, though. I did high volume cases. So easy for me to say. But again, that's how I see it. Like, it's, if you have to try to shoehorn a case, you don't have a case. So stop it. But that's how I see things. Sarah Ham said, Emily, I worked in civil law for over 10 years. We just had a case settle after 14 years of litigation. So this seems easy peasy to me, right? They've only been at it for like 2 years. And this isn't even getting us started on the contentiousness in family law and divorce. Like, we're not even there. We're not even there. A number of you are asking how the cats are doing without tea. George is grumpy, and there are times that it just makes me so sad because he'll like hear the garage door open. The other day we were driving Travis's car and brought Travis's car back, and George heard Travis's car, but there was no Travis. He was not pleased. So he's okay, but he misses his person, and you can tell. But he's allowing us to be support humans, but he misses his human. But I put Travis on speakerphone when he calls, so George will come and listen to his human. But it's hard. That's his person. So it makes me sad, but he'll be okay. He'll be all right. But it makes me sad for him. But I also love that he just absolutely loves his human, and his human misses him too. So it's hard. George sometimes meows at the phone. It depends, but it's different when somebody's, your household changes when there's somebody not there. So I miss my kiddo too, but I get to see him this week. So I'm not going to get all emo about it. I'm very excited to go see Travis. And it's also why when he calls, it's like, oh, we're going to be a little bit late. T is on the phone. So but it's hard. And it's different. And it's different than last summer, because last summer, and then we're going to move on, but it's different than last summer. Last summer, when Travis left to go on tour, we knew that he was coming back at the end of tour, and we knew that he would be back home for the school year. This time, when he gets to the end of tour, he's going to be in college. And that's different. Meow Now said, quick note, EDB, you should see Dave Matthews in the Gorge. I have been to the Gorge. Unfortunately, the Gorge is not going to work this year due to all of the life things. My sadness over the lack of Dave Matthews concerts on my calendar this year cannot be understated. Because it's just so sad. It just makes me so sad. However, I'm real excited to go see my kid perform. And so my lack of Dave shows on my calendar this year, I'm going to have to deal with. Adulting is hard. But I love the Gorge. It has been too many years since I've been to the Gorge. It is one of my favorite things. I've been a couple times. I love a Labor Day weekend. Not being at the Gorge last year as the set lists were coming out just hurt my heart. I was like, no, the entire album in order. No. But we can do hard things, and we can adult, and we can FOMO, and it's going to be okay. It's going to be okay. It's going to be okay. Because also I have, I get to go see my kiddo perform. And that's also a limited period of time. I have gotten to go see Dave perform since well before my kiddo was ever even a thought. My first Dave Matthews show was in 1996. So I've gotten to see lots of Dave. It is going to be okay. Travis getting to perform, and performing is a much more limited time, whether he performs every year until he ages out or whether he doesn't. It's much more limited in time. For those of you that are new, my kiddo does DCI. It's Drum and Bugle Corps. It is, as they reference themselves on their website, it is the major leagues of marching band. And so DCI season is upon us. And again, that is it's a shorter season in life, getting to go see your kids do stuff like this. It's great. And that season of life can pass quickly. And also, I'm going to get all emo. And also, I am acutely aware, because of my own life and life path, that you never really know when it's going to be the last time. And when I got hurt playing water polo for the last time, I didn't know that my last game was my last game. Like, some people know, and that's fantastic. But you don't know what you don't know. And so because I had that experience, I am very mindful that this season can be much shorter than anyone thinks it will be. And I try to approach my opportunities to get to see my kiddo with that in mind, because it was hard for me, but also it was hard for my parents, that you don't always know when your last game is going to be your last game. So emo Emily. So I try. And those, I will make it to another concert. It's just not as many as I would like. I should have been a roadie. Oh, Emily, what are you talking about? Your knees are shit and you don't like heights. Life is the thing. and it keeps lifing. But it's such an incredible thing to get to go see someone that you love, my kiddo, on NFL football fields doing the thing that he loves. Like, there's nothing in the world that you can trade that for. There's nothing in the world that you can trade that for. So, even though sometimes I'm sad to miss the concert because both can be true. All right. All right. Salapi said, will you have your lawyers with you at a depo? Yes. You are not going in alone. You are armed with a fleet of lawyers. And so you have a fleet of lawyers with you at your deposition. And that's why we heard in the Proctor hearings, they said we didn't even know Proctor wasn't going to show until we reached out and asked for the list to give security of who was coming. Right. Let's see. Angela, thank you for the 10 gifted memberships. New members, remember, we do have a members only tomorrow. We've got some things to talk about tomorrow. So don't worry about that. We got some topics. Let's see. I am trying to answer questions. I see a lot of you guys. I am back up in the stream to talk about our first story from Kouri Richins today. Oh boy. Ad Commit's now trying to imagine Emily living the roadie lifestyle. I would be shit. I would be absolute shit. A, I do not do well not sleeping in my own bed. Let's start there. I would be shit. B, my brain has very specific working hours. However, my brain's working hours are much more aligned with working at night. So that might be good. Also, I get motion sick. So bus life, I would also be shit at. But I love being around music. Oh, also, I have a very a Goldilocks temperature span that I'm good with. So I could never. It's such dynamic and hard work. Bus driver might work. Becky, you might have hit the nail on the head. Becky's but Emily drives a bus. I do love to drive. This was a missed calling. I do love to drive. Can you imagine? Kids, keep it down in the back. Mama's trying to focus. Yeah, amazing. Which is basically how I feel about this summer, is me driving all over the U.S. to go see my kiddo. Let's see. I'm going to answer as many as I can. Juniper said that Colin's MIT will make him available, willing or not. I agree, but I think they were setting up. I think they were setting up the other side of that argument. We started seeing them set up we can't physically get him here. He's been rehomed to the property of the United States military. But we started seeing the other side of that argument with we don't have time to prepare. We started seeing it. We started seeing this. Cujo said, Emily, I'm super confused about the O'Keefe suing for wrongful death. I get this is civil versus criminal, but how isn't the evidence the same? The standard is different, Cujo. So what needs to be proven, and it's been a long time since I've gone over the complaint in this case, but the standard of what needs to be proven is different than beyond a reasonable doubt. And you can have criminal acquittals and a civil finding of wrongful death. It is not anathema that can happen. It happened in the O.J. Simpson case, I think, is the most famous example of somebody being found liable for wrongful death while being criminally acquitted. This case, I am not suggesting factually are the same, but the beyond a reasonable doubt standard is very different than the civil standard. And the civil standard can account for different ways that somebody's a contributing factor to a death. And so that is why we are getting into a wrongful death litigation. though, we're just going to have to see it play out. The discovery on this is going clearly to be a very big fight. And the wrongful death case is about the wrongful death, but it's also very much about things Karen Read said in her own defense with the infliction of emotional distress. And then you have the spin-off defamation case. And then you have the spin-off deprivation of rights case. It's like, and then. And they're all like intertwined with thread, but separate cases. It's a very complex series of litigations. So that's, the facts may be the same. Also, on a side note to that, the facts that can come in a civil case with what's been pled is also going to be broader than what came in at a criminal case. So there's a lot more there. And the jury has a lot more options. But it's going to be so very litigated. So very litigated. Miss Mandy, I'm so sorry for your loss, but also 18 years, what a blessing. But also, homes feel different when our paw nerds are not there. Big hugs. I'm sure the chat already gave you all of the hugs. It is hard. Hello said, question, why did it feel like we never got answers about Colin? Because we didn't. We got just a, jump to the right. No, left. And then a step to the right. We got wiggle it and wobble. All of it. But no, we did not get a direct answer of, we'll talk to our client this weekend and we'll let you know. No, there was no direct answer. There was no direct answer. Right. Yeah, because we didn't. You are correct. Your feelings are correct. Chat, your feelings are correct. Let's see. Can I hear the turkeys at Emily's garden? Not today. They were very active yesterday, but not today. Let's see. Showjumper Red said it seems like the lawyers are also completely negating his advanced individual training, which, if I'm not mistaken, typically takes place immediately upon completion of basic. They said that there would be a break after 10 weeks, but also his lawyers keep changing. His lawyers keep changing if he's in basic or not basic and this and this and this. I don't even know. And then they're like, he'll have a break in the fall. I don't know what's happening. I want more information. JPJH says, as a vet, thank you for your service. I don't get the whole Colin isn't basic training argument. He is a third-party witness in a case, a plaintiff in another, and a witness in a victim in a criminal case. I have as many questions as y'all do. And I imagine that at some point that is all going to bubble up to the top. We're just going to have to wait. And we will see. Avrils asked, is split opinion still not a thing? I need to take a look on the civil because it would be odd to me if they couldn't find liability on some civil counts and not the others. Not a undecided, but they could in civil come back with liability on some and not liability. I guess that really wouldn't be split in Massachusetts. The split that was frustrating for Massachusetts was to have verdicts on some counts and then hung juries or undecideds on other counts. And I imagine that would be the same in civil if they couldn't reach agreement on some counts but could on others, but I would need to look. Jennifer asked, if this was criminal, would it be different? Yes. Well, we have seen a lot of BS in discovery and criminal in Massachusetts as well. So I can't say for sure it would be different because we have seen similar discovery fights in criminal with the whole inverted video and then the motion to dismiss or the motion for a new trial based on the inverted video. And then it was like hiding in a file. Oops. Oh, there's more video. Oh, there's not more video. Oh, That one's inverted. This one's not inverted. This one doesn't work and has never worked. And we just never really noticed till now. So it should be different. But we've also seen a lot of civil discovery fuckery, including in another case, in the Miles King case, we've seen Lally take the stand and be asked about why discovery hasn't been turned over. And he's like, well, Proctor never gave it to me. Did you follow up? I mean, like, discovery is an ongoing obligation. So vibes? Like, I'm sure we'll get it eventually. So criminal discovery should go smoother, but it seems that maybe the discovery rules in Massachusetts don't carry enough teeth because nobody seems to care. Everybody's just like, it'll be fine. Whatevs. Nobody seems to have any hurry at all. Everybody's just like, we'll see. Wild. So yes, generally criminal should go a little smoother, but Massachusetts discovery has been challenging. So Maria said the judge gets frustrated but acts the opposite. Yep. It's been real frustrating because the judge is like, it has to mean something. Hey, Your Honor. You know who can make it mean something? You can make it mean something. And the reason is Your Honor. You can, grant the motions to compel. You can make the parties do the things. Raise your pen and just say, by the power of Grayskull, come on, Your Honor, you can do it. So yeah, it could be, but it's not. SwanX fan said, told my boss to look up Goose v. Gander yesterday. I love it. Our law nerd binding precedent continues to expand, and I'm here for it. I'm here for it for sure. Jenny in the World said, I'm from Argentina. My older sis moved to Germany. I totally understand, George. That is a long way away, and I feel you. It is. I feel the same. I feel for George. And so when George kind of comes over and hangs out with me, I'm like, I know, buddy, I feel the same way. Tiffany said, Emily, do I need to come bug my brother at Lucas Oil this year and save you from my family? A, Tiffany, no saving needed. And B, yes, please come hang out. I'll be at Lucas Oil for days and days and days. And I shouldn't be hard to find. Ree said, Buc-ee's opened in Phoenix. What do you suggest I get when I finally go? Chat, I hope you were putting in suggestions. There are so many options. Pace yourself. And I love all the pickle flavored things. I love the pickled popcorn. I love the pickled. We love the pickled. The brisket is fantastic. They have like a brisket mac and cheese that's really good. Their prepared foods I very much enjoy. I would say don't get overwhelmed. Look for the types of foods that you enjoy and know that, you'll make it another trip. But also trying the different things, the potato sticks in whatever flavor you love are quite good. The Buc-ee's merch is hilarious and lots of fun. Their pajamas are actually really soft. If you need some Buc-ee's loungewear, it's amazing. One of my favorite mugs for Halloween came from Buc-ee's because it's also got all of the themed and seasonal mugs and cups and everything. I would also give it a beat because if it gets crazy at opening, I would give it a beat. Waiting 30 minutes to get a Buc-ee's sandwich is difficult for me. but it's so much fun. Like, it's so much fun. So enjoy the spectacle and the fun, and then try all the things. But I still have some, actually, and we're getting ready to go to Buc-ee's again. So now I feel less bad, but the flavored popcorn is my favorite. Tip Top Pop Dill Pickle. Oh, also, hold on. I was on my last bag and I didn't want to open it, but now I know when I'm going to Buc-ee's again because I know my travel schedule better. So now I can eat the popcorn this week and I'm very excited. Emily, are there snacks by your desk? Yes. These are fantastic. The Ripple Chips and Queso, the queso flavor is fucking fantastic. And you just have to try it. Just get a bag of these and try it. They are so good. I love a snack food. I love a road trip. So, yep. And we get Buc-ee's sandwiches all the time. So Buc-ee's sandwiches are one of our go-tos. All right. What else? I do ginger for motion sickness. I do. And generally I drive the best that I can. Buses are a little bit harder, but if I have a window, I generally take care of myself a bit better, and I've learned. But yeah, enjoy the Buc-ee's-ness of all of it. So enjoy the Buc-ee's-ness of all of it. Purple Prickly Pear said they're accusing them of canceling the deposition. So wouldn't they have been prepared previously? So they wouldn't have been prepared previously. It's a fair point that they were saying, well, the depo got delayed. I think we're going to see an argument that they don't have time to prepare for the deposition. I think we're going to see that. Let's see. I think you would love Judge Mogan from Wisconsin. She makes things happen. And thanks about my sis. I do miss her, of course. And yes, I think there is a balance of judges that are dealing with the reality of cases and situations. And then I think there's also, hey, everybody, a deadline would really make this move better for everyone. So we're gonna stick to some deadlines. Let's get moving. And some judges strike that balance differently than others. There are a lot of moving pieces in this case, but it is also coming up on its discovery deadline. But also that discovery deadline for the Reed parties has been a year versus 2 or 3. So it also is, in all civil things, a bit faster and a shorter time for Reed's team because they had the stay and then the discovery didn't bump out another year. I think where we get to at this is, will the court extend the discovery? And I think that's inevitable that it's going to happen. Green Eyes said that Colin lied on the Army application. I don't think that that's been verified. I know that there is lots of discussion and speculation about that online. I am not convinced of the veracity of that. I'm going to wait till we see this play out in court because with personnel records from the Army, there is not an easy way for those things to be accessible. I think there's a lot of speculation about that. I do not think that that is a fact. And I have not seen that. I have not seen that in a way where I trust that 100%. I do have questions about that. But I don't know if that's, I don't know if that has been proven because you're not going to have the records from the military, but I have questions for sure. A lot of you are saying you saw it. How do you know that it's true? How do you know that it's his form and that somebody doesn't just create it and sign it? I have not seen that in a way that I trust the veracity of it. So that's where I'm at. But again, I will wait and ask questions and see what happens in court. If that's true, then we will probably see the consequences of that. So I'm not too pressed about it. But those records would not be available to the general public, especially at this point. So there's not a way that that true document would be available in the public. But it's not a hard document to pull off the internet and fake. So veracity is something that I question heavily when I see things. But that's not saying that I don't think there's a huge question there. I think there's a huge question there. I think it is something that we know that you have to select on an application, but I'm not going to accuse someone of not being truthful until we have more information. I have questions about whether that was disclosed, of course. However, we do not know yet. And I think at some point we probably will. So we can just, I know I would rather have the answers too, but I would rather have the answers from his lawyers. But we know that that needs to be disclosed. We'll see if it was. His lawyers haven't addressed it. Karen Reed's attorneys are like, I've got questions. And we'll see if we get to the answer of that. Or we'll see if we get answers to that and if we get to the bottom of it. But no, I'm not taking I don't know if that's true yet. So I will always err on the side of let's wait until we have the facts. But Jenny Ann, I'm with you on this one. Jenny Ann said someone will fall on the sword and testify we told him it was canceled. I think there's a high likelihood of that. And it's not just this. Here's my questions go beyond this, because it's not just about him being a third-party witness here. And if he was just a third-party witness here, I would think about this differently. But he is a plaintiff in another case that he initiated in April of this year. There's no forgetting that you're a plaintiff in a case you initiated in April of this year. He was over the age of 18 when he initiated that with others, and he is a victim in a criminal case. Those two facts raise a lot more questions for me than the fact that he is a subpoenaed witness in this case. So I have a lot of questions about that. But Law and Disorder said, I'm pretty sure you can't FOIA his application. I have never seen people be able to FOIA personnel records like that from the military and that type of thing. So I've not seen that. So there is that. And this is helpful as well. JPJH said, for everybody mentioning the SF-86 form, please note that that's a security clearance application, not an enlistment application. And those are two very different things as well. But again, we will have to wait and see. There are going to be questions that we don't have the answers to yet that we're going to have to wait and see how it plays out. I know that that's not as helpful, but I think that taking a beat and waiting to see what happens, because I do think we will have answers to this, and I do think we will have answers down the road. So I know that the waiting is frustrating. I would rather wait and see how it shakes out than A, share with you guys wrong information, and B, when it's information we think we're going to get, there's not a lot of need to speculate about it. So we'll get it. Let's see. We will see. I know. It is one of the things that has, I think, gotten harder and harder and harder to do. And it's something that at the beginning of law school, I was like, wait, but can't we just? No. And throughout my career in law, it is much easier for me to take a step back and be like, what questions do I have? What processes are we looking at? And will those questions get answered in this process? And then know that I have to wait. But we live in a bit more immediacy, and that feels like it's getting faster and faster. Like every passing month, it feels like the immediacy is getting quicker and quicker and quicker. And it's hard sometimes when the court process moves so slow, when everything else in our lives moves much, much, much more quickly. And unfortunately, unless you come back in a few years, we can't binge watch these civil cases happening. We don't get to the answer. And that's part of the thing with court, is you never know what's going to happen next. All these parties could decide to settle tomorrow. I don't think that's going to happen, but we never know. It was like the day, do you guys remember who was here? Put a 1 in the chat. Who was here watching Baldwin live with us on day 3 of trial? Just put a 1 in the chat. Because day 3 of Baldwin, the speculation was wild. And we as a chat had a little bit of a chitty chat, and the mods were doing all the EDB work, because I'm like, guys, speculation's not helpful. The mods were doing all the work. It's also one of the reasons I say no breaking news, because I like to verify things a couple different times before we talk about it. And so, like, breaking news just needs sometimes a little more time to verify. But at the beginning of that day, on day 3 of that trial, there was a bird outside treating my bird bath as like a bidet. That's hilarious. It's just like having the best time with the fountain under the tail feathers. That's hilarious. Not the turkeys, smaller bird. But at the beginning of the day, I was like, the defense is throwing all this stuff up on the wall. Let's see what sticks. And then as the day kept going, the judge got off the bench and was like, no, we need to look at that. I was like, oh shit, this is getting crazy. Like, this day is getting crazy. And then they took an extended break. And the internet, not the Law Nerd chat, because the Law Nerd chat knows better, but the internet had decided that there was going to be some kind of a plea deal. And I was like, y'all, we're not running down that road. There is something going on. There is something going on at this extended break. We do not know what it is. There is something happening. It's not a plea deal. And the internet was like convinced that, not y'all, because we were here, that somehow they were working out a plea deal behind the scenes. I was like, that's not what's happening. And then we get back from this extended break, and it seemed that the prosecutors had been fighting behind the scenes to dismiss the case and fighting with each other. And then Erlinda like walks up and fucking quits. And we don't learn till Carrie Morrissey gets on the stand that they had been fighting over lunch because Erlinda was saying this case should be dismissed. We didn't even learn that till later. The delay was because the prosecutors were fighting with each other. There wasn't a plea deal. They were fighting over what their ethical obligations were. And Erlinda fucking quit. Walked in and quit. In the middle of trial. It was crazy. And I've never seen anything like it. But waiting to see what happened was crazy. And then the amount of speculation was crazy. And then I was here being like, hey, you guys, we're going to find out what happened. But we don't know what's going on. It's not going to be a plea deal. Not with all of this. Not with this much going on. It's not going to be a plea deal. No defense attorney in their right mind with all of this going on and the judge coming down off the bench. No defense attorney is going to take a plea deal today. Shit's happening, but that's not what the shit is. We don't know what the shit is. Shit is happening. We're going to have to just wait. Just wait. Please don't come into the chat again and say, oh my God, did you hear he's taking a plea deal? That's not accurate. And so the mods were very busy because people would see people talking about it and then come back to the chat and be like, oh my God, is this happening? And so I felt like we were like on loop of like, I don't know what you're looking at elsewhere on the internet, but that's not what's happening. What is happening is wild. We just don't know yet. And it was such a crazy fucking day because we could never have anticipated that during that extended break, the defense was telling his client, this case is probably getting dismissed. Just hang in there. And the prosecutors were fighting over what the ethical thing to do was. And you have Erlinda, who is a special prosecutor who had been a federal prosecutor. And then you had Carrie Morrissey, who was also appointed special prosecutor. I don't know if she'd ever worked as a prosecutor. Mostly worked as a defense attorney, fighting over what should happen. And Erlinda's like, I quit then. It was wild. But whatever we could have come up with wasn't that. Whatever speculation we could have sat there and speculated wasn't any of that. What was going on behind the scenes was so much crazier than we would have guessed, which is why it was really hard waiting to see what happened. And all we knew was that shit was going down. We didn't really know what shit or where it was going down or what was going to happen. But if you go back and watch that stream, the beginning of the day is, so the defense is trying to throw stuff up and see what sticks. The middle of the day was, oh shit. Some of that stuff is sticky. And then we got to, oh fuck. I don't know what the judge is going to do with it. This is really bad. This is bad. This is real bad. This is real, real bad. And then we got to the court dismissing the entire case. And I was like, holy fucking shit. And now we're done. One of the craziest days in court I've ever witnessed. But it's also why I am always very cautious about A, vetting information, B, pushing back on the unvetted information that grabs at your attention and your emotions, the salaciousness, the quick, somebody is saying that this is what's happening because they know. I push back on that quite a lot because I don't think it's helpful to just grab at attention with unknowns. It just creates more loops. And that's not how I like to do things, which is why I tend to wait and then share with you what we're waiting for and what we do know and what we don't know, because that's how I process information too. So with all of that, that is my cautionary tale of remember that day in the Baldwin case? This is why Emily vets information through multiple sources before we chat about it. It was crazy. We will check back on what happened with Carrie Morrissey. She got put on the Brady list, but as a defense attorney, I don't think that matters all that much. And that it was crazy. But it is hard sometimes to wait for the facts to unfold. However, when I love the big reveal when we get there, and it's not nearly as satisfying if it's all just, disclosed beforehand. Sometimes watching what happens in real time and going, holy shit, I didn't see that coming, is wild. Because one never knows. So it is one of the few areas in life where we actually have to wait anymore. I mean, I'm a girl that doesn't like to wait very much either, but it's one of the areas in life with court where we actually have to wait sometimes years for results. Waiting for the Supreme Court in South Carolina was miserable too. Months and months and months and months. I mean, it was probably harder for, Murdaugh, who's like trading beef sticks and calling his lawyers, being like, Jim, anything from the Supreme Court? I mean, that's just how I think that goes down. But it was waiting for the Murdaugh decision took forever. And that's a decision that I thought they were going to do what they ended up doing. And it took forever. And then when they did it, I was like, oh shit. And then they did it on a day we had other shit to do. Fucking Supreme Court. Well, we're in court on another case. Dare you not consult our schedules? It was wild. So I know it is hard when things are popping off to not get swooped into the immediacy. There's times it's hard for me too, but I rather take a breath and process the information first and then ask the questions. Because at the end of the day, I don't think we can go wrong when we stick to I have questions. Because hopefully then we get answers. The ADHD thing that's difficult for me is not forgetting the questions that I had when they're not answered quickly. And that's where it is with counsel. So y'all keep reminding me, chat is bae. Chat is bae. Keep reminding me. This is how you keep reminding me about Colin Albert's lawyers not answering the question about whether they talked to their client or not and figured out which days he was available. That question has still not been answered. I don't know if it will be. Keep a note on that one. I'm real curious to see what happens when that case comes back for hearing. Law nerds, it is going to be a busy travel week for me. Members, I will see you tomorrow. Law nerds that are not members, do not worry. I will keep you up to date in the app if anything wild pops off. But with everything that's going on in these cases, most of it is going to move pretty slowly. Because even in the Proctor thing, when we finally got to the end of the day and he was like, you have to go to your depot tomorrow, all the lawyers are like, we can't do that tomorrow. So even when we do get answers, none of them are immediate either. So I will keep you posted in the app if anything pops off. I don't know if it will. I hope that it won't. It is summer. Things in court tend to get a little sloggy in the summer as well, where things kind of slow down a bit. I cannot wait to go see my kiddo. Don't worry. I will be sharing on social and in the app. If you follow me on Instagram, you will see it there. If you're in the app, you will see stuff there. But I will be sharing a bit of the Cavaliers Lost Boys. I will be shamelessly sharing my kiddo. I think the rest of the core is amazing. Everyone's kiddos are amazing. It's very, very hard for me to not have complete like kiddo tunnel vision, but I get to see a show a couple times this week. So I'm incredibly excited. If you're out and about doing the DCI things this summer and you see me, just please wave, yell hello, say hello. If it seems like I didn't hear you, it's probably because I did not. Just yell again. It's always good to see you when I am out and about. I know some of you will also be in Muncie. I'm excited to see Cavaliers and Carolina Crown. I'll be sharing both shows. I'm not going to just share Cavaliers and not share some of Crown's show as well. I cannot wait. Their show reveals have been really fun. Their music has been really fun. And I have heard not even a snippet of Cavaliers music yet because they have not shared that. And I am waiting. So I will be sharing those adventures later this week. I will be back with you streaming tomorrow with members. I'll be back with you next week for streaming. We will catch up on all of the things that we have not caught up on yet. There are a ton of hearings happening on the 29th. So we will have much to catch up on. And I will do my best to keep you in the loop in the app, but that is also a travel day for me. But there are a ton of hearings on the 29th. So we are going to have a very, very full show on the 30th. So make sure you have the Law Nerd app to stay in the loop. You're not going to want to miss it. And then on the 30th, if they change their mind on cameras in court, we might be in court on the 30th as well. So I'm going to have lots to keep you updated on. Law Nerds, you are the best. Thank you for being here. Thank you, Team Baker. I will see you guys tomorrow. I will let you know in the app and in the YouTube member space what time that will be tomorrow. I just have to check in with Dr. B. It's great to see you guys. And we've got lots and lots of court coming up next week. So I'll keep you in the loop. Y'all take care. Take care of yourselves. If you did not watch the Baldwin stuff, even if you're just like, I can't stand Baldwin, fair. That is one of the craziest days in court. Go watch Russ Trial Day 3. Even if you know nothing about the case, that day in court was so crazy. And I will see you soon. Thank you again to our sponsor, Coveron. Remember, you don't have to go it alone with identity theft. Coveron literally has you covered. Coming to you from Nord. And you know how much I trust Nord with all of the things. Law Nerds, I will see you soon. Take care of yourselves. Be good. I mean, or just go like World Cup party with everybody who's hanging out. If you are partying with the Tartan Army or the Vikings or whatever, I can't wait to see it on social. Have the best time. You guys are the best. See you soon. Thank you for joining me. Make sure you don't miss a live stream or any of the updates on the cases that you care about most with the Law Nerd app at lawnerdapp.com. It's a free download on iOS and Android, so I can keep you in the loop, because you never know when something's going to pop off. Thanks for being here, and thanks for being a Law Nerd.